Pilot item number 49 that was listed before a lordship on 14. And that time when a lordship viewed that this matter is not related to this branch, so direction was to place before the appropriate branch. But today again, my lord, this has been listed before a lordship.
14,
No, 49.
49.
Lordship's order is there. My
This
lord.
is disciplinary proceeding.
This is good.
In terms of last order, matter be placed before the appropriate branch by the registry. As this is the matter pertaining
This is from the
challenging
bank,
the disciplinary proceeding
relating to bank.
relating some Gramin to that bank. District Court. Yes.
Otherwise, I have no, I am ready to do it for lordship, my lord, but
No, but it is not reflected in the subject matter.
in fact, I'll be happy to do this for lordship. What's the place, my lord?
May I please, Your Lordship, I beg to mention for listing of a matter, Lordship, matters pertaining to non-payment of retirement benefit and pension matter, Lordship, despite a repeated order by this honorable court, no affidavit has been filed till date, Lordship. Lordship may fix it on next week, Lordship. There is some urgency, Lordship. On Wednesday, Lordship, if
22nd.
deeply obliged.
May
Yes.
please, your lordship, I'd like to mention item number 36 to lordship 41, your lordship. Lordship, in this matter, I am praying for accommodation for today, your lordship. And moreover, the respondent, they're supposed to file an affidavit, additional affidavit. And we have contacted them also, they were supposed to mention, but it's okay, lordship. It's a joint prayer from both of us.
As per joint prayer, matters can adjourn for 4 weeks.
Lordship, I have one more submission, your lordship. Lordship, in item number 36, lordship, that is a 2024 matter. And what happens, lordship? Only because it is a 2024 matter, it comes below in the cause list, lordship. Lordship, and but the leading case is of 2020, your lordship, that is item number 37. If that makes a leading case, lordship,
How does it make a difference? You pray, point out before the court is
Lordship.
listed.
lordship, we'll do the matter. We'll do that.
You point out.
Much of it. Okay, interim order,
Interim order passed.
much of it.
May I please, Lordship? Lordship, I beg to mention item number 48 with the concern of the other side, Lordship. Kindly be adjourned for a week, Lordship.
Item 48 of the prayer of learned counsel for the respondents. Matters stands adjourned for 4 weeks. Is submitted consent of the council.
Lordship, they were asking for fixed date, Lordship.
They were asking, let them be before the court.
May I please,
Obliged.
Lordship? Lordship, I beg to mention for listing of a WBC matter. Lordship, it's a suspension matter. Can it be-
27th of
26. Obliged, Lordship.
Mr. Lordship, the matter is matter for listing. Three
What is the subject matter?
filing number,
What is the subject matter? What is the matter about?
matter WBC.
What is the subject? What is the issue?
Issue. The matter is related to salary.
Salary, non-payment of salary.
Yeah.
When was it last? It is a new matter.
Yes,
All right, 22nd
22nd.
22nd May.
Mm.
Subject to clearance of defect.
Please, Your Lordship. My lord, this matter relating to the, my lord, the pensionary benefit of, my lord, for higher pension, my lord. The petitioners are entitled for higher pension, but he has been paid, my lord, higher pension by deducting his service, my lord. Kindly see pays, my lord,
In the last occasion, he
Yes, Your
referred
Lordship.
to a judgment.
my lord, last occasion, my friend, my lord, referred one judgment of the Honorable Supreme Court, my lord. This judgment is not applicable in this case, my lord.
Why?
Because, my lord, this judgment relating to the, my lord, contractual employees. Where, my lord, the High Court of this Gujarat, my lord, held that these contractual employees are temporary.
You show us.
My lord.
You show us from the relevant paragraph. We have it.
Yeah.
We have a copy.
Paragraph 8, my lord.
Right.
Right. 7 and 8, but you keep telling me para 8. And these employees are relating to the, my lord, central government employees, my lord.
Central government, state government.
Well,
The
Para 8,
principle
my
will be applicable.
Para 8, my lord.
Yes.
My lord, under the circumstances, on a fair reading and interpretation of section Rule 13 of
You
the.
read from para 2, para 3.
Para three,
Para 3,
para, para three, my lord. Uh, Para three, my lord. Shri Rajiv Sharma, learned senior advocate, appearing on behalf of the appellant, has vehemently submitted admittedly since
you're reading from this para 7.
para three, my lord.
No.
But I am relying para eight, my lord. Para eight, 7 and 8, my lord. Okay, we have this, my
The
lord.
facts of the case are starting from para 3 onward.
Three, my lord.
Yes. Do you have para 3?
Three, my lord.
Is it an SCC publication? Is it an SCC printout?
Yes, your lord.
SCC online?
No, no, SCC no, my lord. It is a online print. On-
We are holding an SCC
I
online.
have two copies, my lord.
We are holding an SCC online copy.
I can help him.
Para 3.
Para three, my lord. That the respondent hearing, original applicant was engaged as a general assistant on contractual casual basis in the year 1985. The services of the respondent as general assistant on contractual/casual basis were thereafter extended from time to time. However, with break of few days, the original applicant thereafter filed original application number so and so before the Central Administrative Tribunal, Ahmedabad bench, Ahmedabad, for short the tribunal. The said OA was partly allowed by order dated 38/1990 with a direction to the department appellants herein to pay her the same salary and allowances that were being paid to other regular general assistant clerks from October 1990 with arrears. Thereafter, pursuant to the decision of the principal bench of the Central Administrative Tribunal, New Delhi, to regularize casual employees by way of a framing of scheme, the services of the original applicant came to be regularized as lawyer division clerk with effect from 31/3/1995 pursuant to the scheme of regularization of casual staff, artist of Doordarshan 1992/94. The original application was given the regular scale of lawyer division clerk from the date of regularization on the said postman. That thereafter the original applicant approached the tribunal seeking consideration of her past service. The said OA came to be dismissed, which was the subject matter of writ petition before the High Court. The High Court was pleased to permit the original applicant to submit representation to the department. That thereafter, the respondent original applicant submitted representation dated 11/4/2014, while order dated 18/9/2014. The department rejected the representation of the respondent for giving her the benefit of casual/contractual services rendered by her from 1985 till 31/3/1995 for calculating the pensionary service benefit. Thereafter, the original applicant filed another OA number so and so before the tribunal by a detailed judgment and order dated 8/9/2021. The tribunal dismissed the said OA by observing that the services rendered by the respondent as contractual casual cannot be created on or considered as temporary service, and therefore the service rendered as such shall be counted for the purpose of retirement benefit. Shall not be counted for the purpose of retirement benefit, service benefit. The judgment and order passed by the tribunal dismissing the OA was the subject matter of writ petition before the High Court. By the impugned judgment and order, the division bench of the High Court has observed that the services in temporary capacity will include the classes of temporary servants such as casual or even contractual. By observing so and relying upon Rule 13 of the rule applicable, the High Court has allowed the writ petition and has directed that the services of the respondent, the writ petitioner rendered as contractual, casual shall be liable to be counted as temporary service for the purposes of calculating qualifying service in accordance with the rules, and accordingly she shall be paid the pension on her retirement. The impugned judgment and order passed by the High Court is the subject matter of the present appeal. Para 7. Sri Rajiv Sharma, learned senior advocate appearing on behalf of the appellant, have vehemently submitted that admittedly since 1985 till her services were regularized on 31/3/1995. The respondent rendered the services as a casual contractual employee. It is submitted that the services rendered as a casual contractual employee cannot be stated to be rendering services as a temporary employee and or rendering a temporary service. It is submitted that therefore proviso to Rule 13 of the Central Civil Services Pension Rule 1972, hereinafter referred to as the 1992 rules, shall not be applicable, and therefore the service rendered as such as casual contractual employee cannot be counted for the purpose of pensionary benefit, service benefit. 8. It is submitted that the High Court has therefore misinterpreted Rule 13 of the 1970 rules and has materially erred in observing and holding that the service in temporary capacity will include the classes of temporary service such as casual or even contractual. Making
Now, Mr. Hendik, how do you say this judgment
My lord,
covers this issue?
para materia provision is there in Rule 36 of our Assam Pension Rules, 1969. Rule 30.
That was there when Fazle Rabbi judgment was also rendered.
My lord,
This
but
provision is not inserted subsequent.
my lord, but now it has been reinterpreted in a different light
No,
altogether.
this is in terms
The
of
principle of Rule 36.
no. This is in terms of a scheme for regularization. Kindly come to para 12.
12. As per scheme, my lord, in this case also, what had happened is that in the year 1991, they were provincialized. Subsequently, they were
The whole purpose of Fazle Rabbi is to recognize the earlier services rendered
my lord,
and count them for the pensionary benefit.
my lord, that is absolutely true. In Fazle Rabbi's judgment, there's an observation made by the court. There's a finding of the court which says that in 1991, they were initially provincialized and subsequently, my lord, posts were created and they were regularized against those sanctioned posts. So similarly, in this, there was a scheme of regularization in Fazle Rabbi's case also. It's there in the judgment, my lord. Similarly, in this case, 1985, they joined as casual employees. Subsequently, they were regularized in 95. So now the petitioner, the respondent stand here was that their services from 85 till their regularization should also be counted as qualifying service. In our case in Fazle Rabbi also, whatever be their date of appointment, till the date of their provincialization and subsequent regularization, they were rendering services as casual employees. They held a substantive office or a substantive post after they got regularized. So that's why this ratio of this judgment holds fit.
Fazle Rabbi judgment,
Talks about post, talks about the post part.
so Fazle Rabbi has considered persons similarly situated. Matter has traveled to the Supreme Court. Supreme Court has rejected PSL.
My lord, but this is, my lord, I'm on the principal part, my lord. That judgment of Fazle Rabbi, inter se the parties, their rights have been crystallized. But subsequently, these fence sitters who have now approached this honorable court, relying on Fazle Rabbi, cannot do so because that is bad in law in light of this subsequent judgment. The
That is-
principles,
Can't say that is bad in law.
at least the principles are not like binding anymore because
No.
this judgment,
No. The ratio in Fazle Rabbi is what is the appointed date and how is this to be?
but my lord, Fazle Rabbi says one more thing, that the qualifying period will be counted from the date of your initial appointment and not from the appointed date. So if we go by that interpretation, in that case, the entire services whereby they had rendered services as a casual employee will also be taken into consideration,
Correct.
which
That is-
will
that is the
go
ratio.
against
That is the ratio of Fazler.
which will go against this judgment, my lord,
No,
because
this
they say
judgment-
that casual
No, see,
services.
it is factually distinguishable because there is a scheme for regularizing.
Here also, my lord,
In this matter.
in Fazle Rabi also there was regularization, my lord. If you don't take into consideration the scheme word, regularization was there in Fazle Rabi as well.
So you have to take into account the scheme word because the scheme lays down the procedure, the qualifications, etc.
Agreed. Here
Now,
also there's a
here in
scheme, my
Fazle
lord.
Rabi, the question was with effect from the appointed date. Are they entitled to the benefit of the services rendered prior for being counted towards pension, or it has to be counted from the appointed date?
My lord, in
The
Fazle,
state held that it is to be counted from the appointed date. The same argument you are making now.
but my lord, at that point of time, judgments like these were not there, which specifically
The
talks about.
judgment lays down the proposition on the basis of the scheme for regularization. It come to para 12, very categorical.
My lord, I totally agree. I'm not arguing in that point. There's one issue that I would like to bring to your kind notice. In the year 1991, 4,565 employees were regularized. And subsequently, by formulating a scheme, only these 4,565 employees were regularized. Not more than that, not less than that. That part is very clear in Fazli Rabi's. So this scheme of provincialization and subsequent regularization was only meant to cater to these 4,565 PRI employees who were brought into the fold of the state government subsequently after provincialization and subsequent regulation. So this scheme in Fazli Rabi is also limited to these 4,565 employees only.
Now, it will have to take a call. Why you don't want to regularize them? Whatever reason they have. You have to oppose the submission on Jarvis Brown.
Well, they have regularized and they have been provincialized, regularized, and they have subsequently retired as well now. So that all that has gone, matlab, that is a thing of the past, my lord. Now the only question that remains to be addressed here is whether the period prior to regularization should be counted towards qualifying service or not.
Okay, saying that that is already satisfied. Unless you want to say that no, this that was done with particular scheme that now there is no scheme. That actually
My lord, then we'll file an affidavit to that effect.
matter say, oh, that
Well, the scheme is there in Fazli Rabi because these observations are clearly made. In fact,
see, the government thinks that whatever we have done, we want to know more. That has to be on record. They have to be confronted with that.
my lord, I totally agree. But one thing is that Fazli Rabi's decision holds binding between to see the parties who were there in that relevant period of time.
Principle will apply.
Principle, yes. Principal part I'll address in my affidavit.
Bound to apply. Issue has to apply.
The issue has to apply. My lord, but as far as the scheme part is concerned, the scheme of regularization is, my lord, in fact, I would like to draw your attention to page 61 of the writ petition. First writ petition, Narendra Nath Barua.
Yes.
Second paragraph, my lord, section 3. First, second,
You're
12th
referring
line, my lord.
page
61,
61.
61. 12th line, my lord. Second paragraph. We are told that after the act
Yes.
we are told that after the act had been brought into effect in terms thereof, 4,565, 4,656 number of panchayat employees were provincialized in the year 1991 in various grades, cadres of state service. Following their adjustment, it should have been followed by their adjustment in the existing as well as subsequently created sanction. So their regularization took place. So this regulations,
These petitioners are included here.
no,
No.
no.
That's right.
So the scheme of regularization was
So you
formulated.
have to frame another scheme if required.
So that I'll have
You
to
have
take
to frame
instruction.
another scheme. If similarly situated persons were given the benefit by judgment of this court, taking account of their services rendered earlier, they are asking for the same benefit. And this is a judgment of a division bench. Your appeal was dismissed by the apex court.
But for regularization, I mean, para 53 of Uma Devi also
That's all
needs
right,
to
but
be
these
fulfilled.
are
I mean.
decisions you have to take. You have not taken a decision.
Well,
You have not taken a decision.
file an affidavit, my lord. Let us get the instructions from the we'll get the instructions on this particular, like what can be.
My lord, item 43, my lord, the petitioner is a part of the my lord Fazlur Rabi judgment, my lord.
Yes.
Item 43, my lord.
Then why is he here again?
My lord, he has not been paid full pension, my lord.
Similar issues, my lord.
My lord, kindly see the, my lord, item 43, my lord. He was one of the petitioner of that, my lord, the petition, my lord.
Then you file a contempt. Why you file it?
Earlier contempt was filed, my lord, but that time, my lord, the pension has been started to pay, my lord. So petitioner was paid subsequently, my lord. In the meantime, contempt is in fact to us. And my lord, kindly see
You want
the,
to file your reply response.
We'll file an affidavit.
Lordship, I would like to say that, Lordship, in the Fazli Rabi judgment, when it was decided matter, a right was already accrued to the petitioner's Lordship. That,
Correct.
yes, Lordship, and now, Lordship, my friend, Lordship, he's taking up, he's picking and choosing like few paragraphs and he's making up pieces, Lordship. It is already settled now, Lordship. And and there's nothing to add to it, Lordship. A right was already accrued to the petitioners in 2010, Lordship.
Taken by the government.
Reject.
Taken by the government.
Yes, Lordship.
I thought they perhaps quickly asked them whether
But Lordship, the PNRD department had already issued a notification in 2011 after the Fazli Rabi judgment was decided, Lordship, that initial Lordship that and Lordship, may please come to page number 56 of item.
let it come on 24.
Yes.
At your instruction.
My lord, I need,
But Lordship, I
my
think
lord, 3 weeks time may be given. I've asked for instructions to this effect.
We
In
can
fact-
extend it to 27.
27.
but Lordship,
Obliged, your lordship.
a legal right was already accrued to the petitioners, Lordship. There's no point of yes, Lordship.
Find out if there is the pipeline, whatever they have taken up. Sir, I have picked up
Basically, this is an issue, Lordship, whether the period prior to regularization is to be taken into account or not. One Fazli Rabi is there, but my submission will be, Lordship, one is overruling of principle and the other is overruling of judgment. So far as the present case is concerned, Lordship, that has overruled the principle that the past period has to be taken into account. But the judgment is there. So judgment will definitely apply to those who are parties to that parties to those petitions, Lordship. But the principle will no more act as a precedent, Lordship. That is my
that will apply when they the facts are similar. Fact is particular of the this matter or
Lordship, to that effect,
fact
Lordship,
statement
I
is
mean,
fact in this matter and judgment that you referring are one and the same judgment. There is a scheme for regularization, but scheme has categorically why not be applicable for
Lordship. So initially in this scheme also under the
that particular scheme, the finding that cannot have a clear.
Lordship, I think the department may be granted an opportunity to differentiate both the.
Produce the regulation scheme on the next day. That will make things.
Whatever you want to produce, tell us
27.
why Fazli Rabi should not be
Lordship, I would like to add that in Fazli Rabi, date of was provincialization in 1991, not regularization, Lordship. The issue of regularization doesn't arise in this case, Lordship.
Lordship, that distinction has to be taken taken note of. One is provincial. Lordship, these are employees appointed by the
Yeah.
panchayat. They were paid by the panchayat, not by the state government. So when they were provincialized, at that point of time, they were working as casual employees of the panchayat. Their services were provincialized under the panchayat. not under the government. Subsequently, in the year 2005-6, they were brought under the government, state government. So in spite of being provincialized, they were provincialized as panchayat employees, not as state government employees. That distinction will always prevail, Lordship. That was never taken into account of. That is the issue, Lordship, basic issue.
In particular,
Lordship, that was not taken account of. They were provincialized only under the panchayat. When then they were paid by the panchayat till their regularization in the year 2006. Post were created,
even subsequent to
post provincialization, they were paid by the panchayat. Only in the year 2006, Lordship, 2006. When they were regularized by the state government, they were paid.
they retired.
Lordship, petitioner in item number 3 retired in the year, Lordship, 2001.
Prior to retirement.
Lordship.
That means they are still casual.
Lordship, but it is not applicable because if there be already a right was accrued to the petitioner's Lordship, like to all the similarly situated persons, Lordship. Whether regularization, Lordship, the issue of regularization doesn't arise in this case, Lordship.
We take it up on 27. 27. Get your instruction. It's on 37. Enabling the state council appearing for PNRD.
Yeah.
Complete his instruction. In respect of MS R. Burman, P. Burman,
Arbor, Lordship.
and Mr.
M. Islam.
Diamond. M. Islam appears for
Item number 1,
1 and 2.
1, 2, and my lord, the 42, 43, 44, and 48, same matter.
42,
42, 43, 44.
40.
45.
Lordship, I'm appearing for, I'm appearing in item number 3 and 45, Lordship, item number
3 and 40.
3 and 45. Lordship.
Yes. 27. List on 27. Yes.
Lordship, as regard the contractual provision, we couldn't find a judgment uh, regarding that. So Lordship may pass an order in that regard. We couldn't find any contractual provision.
You are relying on the Madras High Court.
Madras and Supreme Court is also there.
This is the Madras. We have it.
Yes.
Then you mentioned some Supreme Court judge.
Supreme Court regarding the
Where is the contract?
Lordship.
Contract agreement.
Yes.
Is it available here?
No agreement.
No agreement.
Appointment order is clear. petition from
Annexure 10.
petition from the
Annexure Annexure 10, the communication.
Okay.
page 22, the last page, that will tell him at the
Statement of rectification.
copy. I think 2A defines continuous service.
Completely on purpose to the certificate.
Now, definition and of uh, continuous service or employee, okay. But you are entitled to payment only under section 4.
Yes.
Section 4 has 3 criteria:
Statutory,
superannuation, retirement, death, disability. So, do you fall in any of the category?
as disengaged,
It can't be termed as retirement or resignation
no, not
or superannuation.
disengagement,
But there is no definition of disengagement.
no definition, but again, your lordship will see page 22 of the note of the department of the HR establishment officer. In case of Dr. B.K. Dutta, retired medical officer, it has been found that though he was under contractual engagement, he had completed 14.3 years of qualifying service without any break in service since his initial engagement with effect from 1/7/2000 to 39/2014. His last consolidated pay was 25,000 per month.
You are representing who?
Lordship, respond number 2, 3 and 4.
Who are they?
So the chairman of 345, 2345. The chairman of the Tea Board of India, the
And-
chairman of the Tea Research Association.
Mr. Bodham. 1 and 2. Tea board. What is the view of tea board? What is your submission? You agree to you have considered to the submissions made by the.
Yes, Your Lordship, but here I would like to make a mention that there has been a recent judgment by the Supreme Court that if there is a provision for an alternate remedy, then the question of writ petition is not maintainable.
Forget about alternative remedy. Tell us of the merits of the case. But your affidavit says otherwise. You filed an affidavit.
Yes, Your Lordship.
You are not very clear. Your affidavit is posing the claim,
Yes, Your Lordship.
and you are now saying that you are conceding the claims made by the.
No, we're not. I'm saying that when there is an alternate remedy,
That is a preliminary objection. We may still exercise a jurisdiction, and we'll give our reasons for that. But on the merits, what do you say? And what is the stand of the tea board? Eh? No. These are objections I'm not asking. I'm asking you on the merits. You tell us from the provisions of the act or any other citations or authorities that. That we can see, but we want to hear your submissions on this. The, if Payment of gratuity act is essentially for industrial work.
Industry, I come on the industry.
Are you an industrial worker? You come under the industry, but are you an industrial worker?
I'm a doctor.
You're a doctor. You're not a tea garden labor.
Not a labor, not a,
You're not a labor.
but any employee. The definition says any employee.
No, any employee, but
Madras High Court judgment helps us to the extent that it clearly states that there is no exclusion clause.
to contract.
yeah.
But that is again pertaining to, I think, a person who
The Palasi.
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 This will require a little examination. This matter will require some hearing.
Otherwise, the retired employees are getting gratuity. Otherwise, all of the retired employees are getting gratuity.
Retired employees are getting
Gratuity.
gratuity. All retired employees. Yes. You have, who has placed this order? This single bench order?
Yes.
You have placed.
Yes, great.
One of them.
We'll need a little more hearing on this matter.
Really, I can elaborate on
Are you prepared to do it today or
it.
want it on?
This may be given shortly.
The matter? You give us your date whenever it is
24th,
24.
Friday.
is it Friday? Oh, 22nd.
Lordship, Senior Counsel Mr. G.N. Sahiwala will not be available on the 24th, from the 24th till the 31st.
22nd. Followed on 13th of June.
Let us have it on 4th of June.
4th will
Fourth
not
of
be here.
You will not be here. 6th, 6th of June. That will be listed. 6th of June. Yes.
K. Bhattacharya
Okay, bye.
for respondent number 3, 4, and 5.
The board may file a, the board may file a responsive demand.
If they want to,
Assuredly.
yes.
Please, Your Lord. Sir. This case is relating to service benefits of the petitioner as per honorable court order. Your Lordship will find page page 67, Your Lord.
Who was the respondent? 67.
Mile. There are 23. May I read it? In view of the above, both declaration of the petitioner husband, Umesh Chandra Bordoloi, as deserter and his dismissal from service, I order dated 31st.
So, only that portion
My
is
lord,
not payable.
my lord.
Has not been.
That portion, your lord. Already clearly directed, your
Now,
lordship.
your objection is no work, no pay.
No, but that is the only lordship.
But the fact is,
Lordship,
they did not work because you declared him as deserter.
no, that is, in the earlier round of litigation, lordship, this court held that he cannot be held to be a deserter because there was intention to come back. So it may be unauthorized absence of leave.
So,
So-
set aside.
Set aside, but
My,
normally that is the view taken, lordship, relying upon two decisions that has been reflected in paragraph number 19, lordship. So in view of that, whether,
No, but that have to satisfy the court. That is.
lordship, there was only direction for consequential benefit. There was no specific direction to pay the wages, lordship. Let him complete, lordship. I'll be relying on 2-3 judgment, lordship.
No, the why we are saying what is the meaning of consequential benefit? Consequential benefit. That is not clearer if it was said all consequential service benefit.
My lord.
All consequential pensionary benefit.
my lord.
Unless the wages,
Consequential benefit.
unless the arrears pay that has been
In the
specifically
division bench
stated,
also
lordship.
stated, your lord.
Now, he was declared as a deserter and dismissed from service.
Lordship,
Both orders were set up.
lordship,
Effect would have been
lordship.
that he is placed in service. But that could not be done because he is fired.
But that he remain absent for more than 1 year, that has been admitted fact, lordship.
Whatever, but that, no, he remained absent.
Lordship, for the period from 9/5/2000 to 1, according to him, he reported on 1/8/2001, lordship. So we have disputed that fact
You
in
have
the
declared him to be a deserter. The order of being declared a deserter here.
He was declared
Right.
deserter on 10/5/2000.
Then 5. Then 5, 2000.
Okay.
And he was absent from
Lordship, he reported on 1/8/2000. Till 9/5/2000 was his period of sanction leave, Lordship. According to him, he reported on 1/8/2001. So more
9,
than,
5,
at least for more than 1 year, Lordship, this period, Lordship, that is his fault, Lordship.
nine five 2000 is leave, his leave
Yeah, so he has on sanction leave till 9/5.
sanction leave.
5/5/2000 to 9/5/2000.
And he joined on
He approached us, according to him, Lordship, on 1/8/2001. That Lordship will find at page 41 of the writ petition.
he's what BSF.
Lordship,
He was employee of what? BSF.
no, Assam Rifle, Lordship. So being a member of the discipline force, Lordship, that part will also. Otherwise, he was given all the benefits, arrear, pension and all those has been given.
And he was dismissed on
It was dismissed, Lordship, on 31/8/2005.
and you're asking your salary from which date?
Salary from you Lordship will find from
Lordship, from 4/5/2000,
4/5/2000 till
19/8/2004.
19/8/2004. As per Honorable Court's order, your Lordship will find. May I read the Honorable Court's order, your Lordship will?
Yes, yes.
In view of the above board,
Paragraph
page 67.
67. Yes, 4/5/2000.
My lord.
So this has been
Para
directed to the regular-
23, your lord. In view of the above board declaration of the petitioner husband, Sumet Chandra Bordoloi as deserter and dismissal from service, I order dated 31st/8/2005 are set aside and quashed. He shall be treated to have been in service till his death on 19/8/2004. The period from 4/5/2000 till 19/8/2004 shall be regularized by the authority. Consequently, Srimati Baijayanti Bordoloi, widow of Sumet Chandra Bordoloi, shall be entitled to all consequential benefit due to late Sumet Chandra Bordoloi, her husband, your lord. All such benefits shall be released, all such benefits to her within a period of 3 months from the date of receipt of a certified copy of this order.
Now, from this 4/5/2000, the salary has not been released.
No,
That has to be released.
Right.
Very clear direction.
Clear direction, as well as division bench also directed you. They have filed a writ appeal, your lordship. Your lordship will find a writ appeal.
Right.
Page 101, your lordship. Their writ appeal was dismissed in absence of me, expiry order, your lord.
During that period, I was in medical, your lordship. That is why I did not appear before the honorable. Take that advantage, they have filed an appeal, but that appeal was dismissed, your lordship. May I read the appeal order, your lordship? Page 101.
Hmm.
Background of the appeals have filed the present appeal. As been above, Sumit Chandra Bordoloi had reported to resume his duty after recovery from tuberculosis illness, TB, but he was not allowed to join. He was therefore constrained to file WBC. He filed a writ petition to join him, but they did not bother about that, which was contested by the appellants on the ground that he had been declared deserter. The deserter dismissed or already set aside by the honorable. The appellants did not dispute that Sumit Chandra Bordoloi did suffer from tuberculosis. They have not denied it. Later, Sumit Chandra Bordoloi also died due to the helpless, due to the disease. He died, your lordship, by fighting for that joining, my lord, before the honorable. On 19/8/2004, due to illness, and this fact was brought to the police of the appellant. When respondent filed an application for substitution of her name in the WBC number 3565/2002, and yet they dismissed Sumit Chandra Bordoloi from service, 5 order dated 31st/8/2005 with effect from 11/5/2005. After that, your lordship, he has already expired. Thereafter, they dismissed from
It's a
service.
very
Very
clear
pathetic.
That part is
what is the effect of regularizing?
lordship. That part is
What is
lordship.
the effect of regularizing?
Lordship will will be entitled to all the consequential benefit, lordship. That is true, lordship. But whether the arrears salary, that part unless
No,
specified in the
No. It is, the period is specific. 4/5/2002,
My lord.
19/8/2004.
lordship.
Period, your lord.
That period has been.
That has to be regularized,
Right.
otherwise he will not get the pension and other benefit. That is,
So
that has to be.
That's quite all right, but what will be the effect of setting aside and quashing the dismissal and
In my respective service, lordship, that area pay that has not been specified.
may not be,
Unless
but then
lordship had to like to die on
And
decision, lordship.
lastly, your lordship will, last paragraph, in fact,
the writ appellate order also is very.
Lordship,
My lord.
with all consequential benefit. That is true, lordship. But whether the
all
arrears-
service benefit, your lordship.
arrears
Then what
salary-
remains?
I tried to find the lordship, I could not find, but normally it has been followed that no work, no pay should be followed, lordship.
Work, pay for someone,
Though that cannot be the rule of thumb, but normally usually followed, lordship.
correct, but pay for somebody still alive and back in service. Then you may say, okay, that period you did not work. That person died,
Lordship.
and you had so much of venom for
Lordship,
the person.
I can't say
Then-
because in the earlier round of litigation, both the litigation, I was not the advocate.
Dismissed him. Person with death.
Lordship, that's true, that's,
How can you dismiss the person with death?
that is on our part, lordship, that's, I do agree, lordship.
Yeah. Whatever is,
Perhaps the affidavit was filed after death, lordship, perhaps.
you were
Because that was communicated.
sure that this man will not get it.
No, that's
Because
not
he's
our
like
intention.
senior officer.
That's not our intention, lordship.
But if we say after his death,
No, lordship, perhaps there was a communication gap, maybe that part, lordship. Lordship McCallie, this 2022 8 SCC page 7, so that is Sushil Kumar Tripathi case, lordship. I'm relying on paragraph number 27, lordship.
Sunil Kumar Tripathi,
Tripathi versus Jagat Guru Ram Bhadracharya Handicap University, paragraph 27, lordship.
27.
Lordship, may I read, lordship? In view of the aforesaid discussion, we find that the termination of service of the appellant was illegal and not in accordance with law. Consequently, we set aside the impugn order passed by the High Court and allow the appeal. In the circumstances, the respondent university is directed to reinstate the appellant as assistant professor in the Department of Political Science and also grant him the benefit of continuity of service only for the purpose of pension and retirement benefit, if any. The appellant will not, however, be entitled to any disbursement of salary for the period from so and so till the date of reinstatement, as he has not worked for the said period on the principle of no work, no pay. The appellant is, however, entitled to notional fixation of salary and other benefit in the event of other pension persons similarly situated to them have been extended. So the next case, Lordship, is AIR 2024 SC 1334. Suman B. Jain versus Marwari Sammelan Prohit Secretary, Lordship. And the relevant paragraph is 29, Lordship. Lordship, may come to the last page at page 9. Just start from therefore, Lordship. Somewhere middle, Lordship. Paragraph 29, last part, Lordship. As page 9, Lordship. Therefore, while deciding question A and B in favor of the appellant, we deem it appropriate to direct the trust to regularize the service period of the appellant from so and so, when they wrongly treated the appellant as having resigned till the date of joining the duty at the new institution as principal and so and so. In fact, the case of the in fact of the case, the
No, these
principal
are
of
all. These
no
are all-
work, no pay
These
would
are all judgments where there
No
is
work, no-
specific direction
Lordship.
of no work, no pay. Here
Lordship.
there is no direction.
No, that's yeah.
But-
This is a case of reinstatement with all benefit,
But
Lordship.
this direction is very categorical, specific.
Lordship.
No work, no pay.
Lordship. That is normally followed, Lordship. That is my humble
What we are
submission.
saying that the judgment of the learned single judge. is
Lordship, may kindly take up the case of 1995 AR SC 1053, Surajit Ghosh versus Chairman Managing Director, United Commercial Bank, Lordship.
Yes.
Here it was with consequential benefit. That will Lordship will find it paragraph 2, the last line. Paragraph 2, last line, Lordship. However, the High Court in the writ petition pending before it by the order dated so and so set aside the order of dismissal from service and directed the bank to reinstate the appellant service with all consequential benefits. Now, what Lordship at page 6, paragraph 6, Lordship. The same principle, there's no work, no pay has been reiterated, Lordship.
You read it?
Lordship. The question, however, is what consequential order should be passed in present case? It will not be fruitful to send the matter back to the bank for re-hearing the matter by the name of disciplinary authority, since the appellate authority, which is the higher authority, has already taken a decision in the matter, and it cannot be expected that the lower authority will take a different decision. So, first, may speak that part, Lordship. It will come to, from the line, the inquiry. The inquiry also prima facie suffers from defect as pointed out above, though we must add that we have not gone into the merits of the said defect. The appellant is an ex-army officer. What is further, the compensation amount be directed to be paid would have come to about rupees 20 lakh. The bank is a nationalized bank and the money belongs to the public. A huge amount of this scale cannot be paid to anyone for doing no work during the long period just because the bank feels that it has lost its confidence in its employees. He can certainly be placed in different department. He has nothing to do with the monetary transaction of the bank as such as the established section. Even assuming the bank has reason to lose confidence in him, we are informed that the part that the post to which he would be entitled to be grade 4 with the basic pay of rupees so and so per month, which is one for the contemporary existing officer of a bank who have promoted to grade 4 on so and so. We therefore direct as follows. The appellant shall be paid a compensation in lieu of his claim of arrear salary. So at best, some compensation amount that can be
Now
lost.
you read further up in the paragraph.
He shall
At one stage.
he should be reinstated in service with
No,
continuity
at
in
one
service.
stage. Further up in the paragraph.
For the
At one stage.
at one stage, the appellant had offered to forego all the arrears of his salary, provided he was reinstated in
This was
service
an
on the
offer made
post.
by him.
Lordship, that's perhaps because the long litigation he might.
No, your submission that consequential benefits will not include service benefits.
No, consider
unless
the
specific.
service benefit will not necessarily include the area salary. That is my submission.
So service benefit will not include area
That's
salary
salary.
unless specifically decided.
That is
us
my
a-
submission. That is my
Definitely.
submission.
So you give us a judgment on that,
Okay.
some authority on that. On what basis are you submitting?
I tried to find out, Lordship, but I exactly could not find out.
Find out. Because his contention is that he wanted to work, but he was not allowed to work. It is not a case that he refused to. We are not concerned with his period prior to the period mentioned here, which is 4/5/2000.
Okay.
From 4/5/2000,
Lordship, at best some
but
compensation.
Mr. Chaudhary,
My lord,
you reported for duty only on 1/8,
my lord,
1/8/2001.
my lord,
Is your own admission.
my lord.
Then why are you claiming arrear salary from 4/5?
Because you said they don't allow us to join in the service, your
No,
lordship.
you
Due
approached,
to,
it is your submission that you approached them on 1/8.
my lord.
So where is the question?
After availing my leave, your lordship, I am the first casual leave.
Your leave expired on 9, your leave expired on 10/5,
My lord,
10/5/2000.
my lord.
And you approached them after more than 1 year.
No, my lord. And then after expiry of my leave, your lordship, thereafter I was in medical leave also. Thereafter I was suffering from tuberculosis. That is why I cannot join after my availing of the siege of the leave, your lordship. Thereafter, I went to the authority to join after a cure, but they don't allow me. Even I have filed a writ petition, your lordship. You read petition, your lordship will find I have filed a writ petition before the authority.
You show us the dates on which
My lord,
you had joined.
my writ petition, your lordship will find. Page 36, your lord. Page 30. My writ petition. Page 39, your lord. Para 5.
What
May I
is
read
the-
it? The petitioner begs to state
What
that
is the
petition.
finding in the judgment of the learned single judge?
My lord. Single judge judgment, your lordship will find. Paragraph 21, you will to find page 66, 21, paragraph 21. Not to speak of desertion even in case of unauthorized absence from duty or overstay of leave. The Honorable Supreme Court in Kursan B. Farmer versus Union of India and others reported in 2012 3 SCC has held that such unauthorized absence from duty or overstay of leave will not amount to misconduct if it cannot be proved that absence is willful. His absence is not willful. If the absence is the result of compelling circumstance, such absence cannot be held to be willful. In the present case, petitioner's husband could not rejoin duty as he was inflicted with tuberculosis. Ultimately, he died on 19/8/2004 in a perverse way. This only buttressed the claim of the petitioner and earlier that of her husband that his absence from duty was not willful and deliberate, in the Impugn order dated 31st/8/2005, it is stated that petitioner's husband had neither been apprehended nor he had surrendered and was still absent. When he had expired, there was no question of being apprehended or surrendering. Dismissing a dead person, that too retrospectively, is clearly untenable and reflects lack of empathy for a dead soldier who had put in about
All right.
20 years of service.
We'll dictate the order in the second half.
Right.
We'll dictate orders in the second half.
Market. So my humble submission, you lordship will see the single judge order clearly stated,
We'll see what can,
nothing low for your.
we'll dictate in the second half.
In this case, my lord, the respondent, my lord, till today, my lord, not file any affidavit, my lord. And my lord, your lordship will pass on order, my lord, on 10/1/2024, my lord. My lord, the petitioner not paying, my lord, as a, my lord, pensioner, my lord, that with a senior. 2015 matter, my lord, till today, my lord, no affidavit filed.
Well, in this matter, my lord, I seek some time to seek instructions, my lord, in the department.
2015, matter what time do you want?
Not
11 years.
The records,
9
my
years.
lord. Just the records, my lord. Whether he was in the zone of consideration during the relevant period of time for promotion or not.
He is not questioning the promotion. You're not questioning the promotion. He's only asking his salary to be calculated.
Salary.
Pension to be calculated at the appropriate scale of pay. That's the only thing.
But you were never promoted. He was never promoted, my lord.
Whatever it may be.
My lord, if it's the question of pension and salary, in that case, verification can be done by the commissioner, and if it is only the question of dues pending.
We can do that, or it is better you call for the record. That will be better. We can finish it off instead of relegating the matter back to the commissioner again.
I'll do the needful.
When can you get your record?
But 2 weeks time may be given.
Let the matter be listed again on 2 weeks. On 27th May, by which date the respondent standing counsel for the PNRD, Mr. Call for the relevant reports.
Doctor, can it be on 29th, your lordship?
29, all right, 29.
Obliged.
Mr. B. Property for the accountant general.
Please, your lordship. I have cited some judgment. You lordship will kindly.
You point out at the
Fine.
time we'll dictate the judgment. The D. Bora for
May I please? Petitioner
Yes.
has not been paid, my lord, his salary, my lord. Since June 2014, my lord, he is, my lord, working. My lord, director, my lord, BTC filed the affidavit, and secretary, my lord, the education also filed the affidavit. None of them, my lord, denied my entitlement. In 1995, my lord, he was appointed, my lord, as a stipendiary teacher, with condition that he will undergo for basic training.
May please your lordship. My lord, Mr. B. Gogoi is on, B. Chaudhary is on legs in court number 10, my lord. PTC council, my lord.
Call him. Call him. You call him.
He's on legs, my lord.
I know he's on legs. You inform him. We are proceeding with the matter. Inform him. Ask him to come when he's completed this matter in that form. Yes.
My lord, thereafter he passed my lord basic training. After passing my lord, his service was regularized my lord. Page 26, kindly lordship. Prepare with my lord. Page 26, my lord. Thereafter, my lord, certainly the petitioner was transferred, my lord, from one primary school to another primary school, page 29. From Poob Rajagod LP school to Rajagod LP school. My lord, the service of the petitioner also confirmed, my lord. The next page, page 30. When he was, my lord, getting salary, my lord, June, my lord, 2014. Now 10 years, my lord, his salary has not been paid. There extended, my lord, my retention is not there. My lord, once the service is regularized, my lord, and confirmed, the question of retention, my lord, should not be there.
His retention was left out.
Yes, my lord.
Name was left out.
Left right, my lord. But my submission, my lord, once my lord service was regularized and my lord confirmed, question of retention does not arise, my lord. But my lord, whole problem perhaps my lord created after transferring him, my lord, page 29, from Poob Rajgad to Rajgad. Page 29. Thereafter, my lord, the problem, my lord, arose.
They do not say, they do not submit in their affidavit, they do not ever in their affidavit.
My
that-
lord, their affidavit, my lord, this director, my lord, can you see the affidavit of director Ravi Shankar Pargayani? He's not denying my entertainment, my lord. Specifically para 4 and para 7.
Where have you stated in which paragraph?
Paragraph 4, my lord. Director. Paragraph
No, in your writ petition.
writ petition, my lord.
You are allowed to draw regular scale.
Yes. Paragraph 16, I have stated, my lord. Since joining since 7/8/92 to 2021, from the date of passing teacher training from 22nd of November 2001, he was getting irregular scale of pay. Part of his salary was stopped from June 2014. The petitioner was paid regular salary till May 2014, but the petitioner has not been informed the reason of such stoppage of salary.
Yes. He was confirmed.
Otherwise, Lordship. Here, we have also filed our affidavit here, Lordship.
Uh,
Only that for want of that retention of permanent,
but someone who is confirmed, where is the
Mm,
scope for retention?
because otherwise, although it is not stated in the affidavit, Lordship, in the affidavit paragraph 5, Lordship, page number 48, filed by the Secretary, Department of School Education, Lordship.
You have not responded to the paragraph.
Lordship.
Just
On
an affidavit. It is not an affidavit, para-wise.
we have
Yeah.
not responded paragraph.
So,
wise.
so the order which is enclosed, the
Lordship.
petition, at page number 30, annexure 9,
Lordship.
clearly shows that they are confirmed. Confirmation in what respect?
On the basis of rendering satisfactory service without break, the following primary school teachers under the subdivision are hereby confirmed as shown.
So they were confirmed
And
on
this is
1/12/2006.
2006 by the DI school. And here, Lordship, our affidavit says, Lordship,
The affidavit doesn't dispute this,
respond to this.
does not dispute. Who is supposed to now pass the effective orders? BTC.
BTC, back to BTC.
Here, right, you call Mr. Call him. I will take it up after a while. Let Mr. Chaudhary come. Mr. Narzari will wait for the BTC standing council.
Yes, sir.
Let him be called.
May I please, your Lordship? Lordship, the senior arguing counsel is on legs in another court, your Lordship. Lordship, may pass over the matter for time being.
I think.
Please read the lord. Here, my lordship, matter relates to the non-releasing of the arrear amount of my lawful salary, my lordship.
Non-release of
Lawful salary.
what
that-
salary?
No, lawful salary, my lordship, that is 2000, September 2017 to May 2019, my lordship. I order dated 15/9, my lordship, I am transferred to Guwahati to Hunachal Jung, that is at page 14, my lordship. Oriendam dated 4/9/2017, my lordship. I was transferred to Guwahati to Jung Division, Arunachal, Itanagar, your lordship. And on the basis of that, my lordship,
You are transferred.
yes, your
Where is your appointment order?
appointment letter. Here, my lordship, we have not, there are three writ petition we have filed, my lordship. Earlier, my lordship. First of all, my name was the typographical mistake of my name, my lordship. I am not allowed to join in my posting, my lordship. That is why that the period of salary, my lordship, stopped, and I am in the last year, I already retired, my lordship. Until today, that,
You show us your appointment order first.
yes, my lordship.
Where is your appointment order?
Here, my lordship, not annexed in this petition, my
Let
lordship.
you produce that appointment order.
Yes, your lordship, we will put it.
The claim of the writ petitioner in the present proceeding is for payment of arrears salary. Stop. However, the initial appointment order is not part of the record. Petitioner is permitted to place it before the court by way of an additional letter. Understand that here for 3 weeks enabling counsel. Petitioner. putting on record to say that initial appointment. And so it-
M. Burman on behalf of Mrs. A. Gayan.
hormone is is after 3 weeks.
3 weeks. Date may be fixed.
Date also you want,
Yes, yeah.
3rd of June.
Online. Okay.
May I please, Your Lordship? This matter is relating to non-payment of pension, Lordship, on the ground that the petitioner fall under NPS. In fact, Lordship, the case is covered by Lordship in Lordship Purnima Hore judgment, Lordship, because the petitioner was initially appointed as a stability sir. After the in 19 Lordship 99.
Mr. Sarma,
Lordship, we have filed our affidavit.
See,
On, in the light of Purnima Hore judgment, your Lordship has passed some similar orders in other matters, Lordship. Lordship may direct similar. Matter বেলেগ এটা আপোনাৰ
নাজানো।
Because here also Lordship, in our affidavit, we have stated a similar way.
where is your affidavit?
Affidavit filed by the director, Lordship. Paragraph 7.
Your claim is old pension room.
Old pension, Lordship. Only thing is that his regular scale of pay was paid from 6/5/2005.
But Lordship, initial appointment was 1999. After that, Lordship, several round of litigations were taken place. And finally, Lordship, in view of the division bench judgment, Lordship, my service was, Lordship, taken again with effect from Lordship 19/6/2004. If your Lordship kindly come to the order dated, Lordship, page 22.
Where is the relevant paragraph here?
And the relevant paragraph, Lordship, in Purnima Hore judgment, that is your Lordship 118, paragraph 118. One 8 Roman 1. In respect of stability, sir. And Lordship, the text, short text is given in respect of stability, sir, in paragraph 23. Other similar person whose service were Lordship taken up along with the petitioner, he has been given the benefit, Lordship, full pensionist. I have an exact order also.
You are a stipendiary teacher.
My lord, page 13 is the initial order.
And what makes you a stipendiary teacher?
My lord.
Why do you say you're a stipended teacher?
My lord, page 13,
13.
second para.
Monthly stipend.
My lord. This is my initial order.
Okay.
Subsequently, lordship, several round of litigations have taken place. And final order, lordship, that is in view of the division bench order, lordship, page 22, your lordship, fine. And in between, lordship, sometime I was placed under suspension and termination was also made.
Had disposed.
My lord. Obliged.
May I please, Lord? Here in this case, my lord, petitioner is paying for pension, my lord, as well as my lord, her arrear salary.
Any reply?
Reply already filed, my lord, and I have also filed my rejoinder also. my lord.
What does the counter affidavit say?
Counter affidavit, they had stated that the petitioner is under the NPS, my lord. At page, there are 9, my lord, my lord. Page 48 internal method. There are 7 and 9 method. The deponent excess government servants appointed on or after 1/2/2005 are regulated by the new defined contribution pension system known as NPS, and the petitioner having been adjusted to after 2005 and allowed to work till her retirement on 28/2/2018, she will be entitled to a pension under new pension scheme and not under the Assam Service Pension Tool. And in para 7, my lord, they have given a details, my lord.
What basis are you claiming your pension?
My lord, in fact, my lord, I am appointed in the year 1994, my lord, in a centrally sponsored scheme at page 17, my lord, in my petition, my lord. I have annexed the appointment order.
Yeah.
As an additional Hindi teacher, my lord. Subsequently, her service was adjusted in the year 1999, my lord. Oh, sorry, my lord, 2000, my lord. Your lordship may found it at page 17, my lord, initial appointment order.
Yes.
And then in page 19, my lord, that is the against the sanction post, my lord, her post was adjusted, my lord. She was adjusted against the sanction post, my lord. At page 2000, from 2002 till 2018, my lord, she is continued as a Hindi teacher, my lord. And adjustment itself is not a regular appointment or my lord regularization, my lord. But it's a accommodation, my lord, against the sanction post, my lord, in the year 2000, my lord, which is prior to the NPS, my lord. And in the year 2009, my lord, when she was again adjusted with a non-existing post, my lord, which was they have rectified in the year 2017. That doesn't mean she is deprived from the pension, my lord. Since she is adjusted in the year 2000, my lord, which is prior to the NPS, my lord. 17 order is at page 28, my lord, when last her attachment was done, my lord, by the government, my lord. As page 28, my lord, annexure 7, my lord.
No, but where is your regularization order?
They have only adjusted, my lord. There is no regulation order, my lord.
How are you entitled to it?
Since, my lord, they have accommodated me with the sanction post, my lord.
Where have they accommodated?
My lord,
Where have they accommodated you? Which order?
at page, my lord, page 19, my lord, they adjusted my service, my lord, at page 19, my lord.
Where is the question of adjusting your service?
One post out of 82.
Adjusting is you are put in a place, but there is no regular appointment. You are given a place in some school. But how do you claim this to be a regular appointment? How will it be a regular appointment? Regular appointment will require process of regular election process, appointment.
But in fact, my lord, she is working against the sanction post, my lord.
Maybe, but her appointment is not regular for her to stake a claim for pension. Merely working in against a sanctioned regular post will not make your appointment regular.
But after long 18 years, my lord, one person is continued in the same
No, that's right. So
sanction post, my lord.
your first prayer should have been to regularize your post. Your prayer should have been for regularizing. Having worked for long 18 years, you have not been regularized. But you're asking for pension. Pension or area salary? Pension.
Pension and arrears salary,
Right, area salary, you are entitled.
my lord.
But pension, for pension, you must be under the subsidy. Under the government, it must be properly appointed. Adjustments are not- cannot be treated. The Katodia,
Yes, ma'am. In any case, the adjustment, he was given the regular scale of pay, my lord, in the year 2009. Earlier, she was in fixed pay, my lord. Initial appointment under some scheme, then she was adjusted in the year 2000 in a consolidated fixed pay. Subsequently, in the year 2009, she was given the regular scale of pay.
That 2009, my lord, that there is no post, my lord, and she was adjusted against the non-existing post, my lord. That is as per their report, my lord. But so far as your lordship, what is regarding my prayer in the regularization, in the petition, my lord, that part I have admitted, my lord.
Otherwise, she is entitled for area salary, and we have processed the area salary also. As because the pension is concerned, my lord, she is under NPS, and she has been given the benefit. She is entitled under the NPS. Yes, gratuity and
My submission is that, my lord, she is prior to NPS, my lord, her service has been adjusted with the sanction post, my lord.
what's some authority that adjustment is equivalent to an appointment?
In that case, my lord, I may be allowed some time, my lord, regarding this issue.
Why are you
My lord,
wasting the judicial time? If
I
you are not
understand, my
ready to
lord.
argue the matter, you don't open up the matter. You know the matter is there for admission hearing.
My lord,
Why have you not come prepared?
I am prepared, my lord, but so far as your lordship's part
We
is
have heard
concerned, my
you.
lord,
You are unable to persuade the court to show that your adjustment order is to be treated as a appointment order for regular appointment. Show us any authority. You have not been able to persuade us. Okay, heard, disposed. Will pass on.
regarding area salary, my lord.
Will pass on.
And so far as, my lord, my only pair is that, my lord, regarding her pensionary benefits, my lord, that part may be considered.
We'll see.
And in this respect, my lord, I just
Yeah.
your lordship one judgment, my lord. Our division bench, my lord.
You give us. Give us your judgment. You hand over the copies. Yes,
My lord.
next matter.
Oblige, Lordship.
Yes, Mr. Togura. The confirmed person. Confirmed in the
Yes.
post. And why pension, etc. are not.
Lordship, from the affidavit that was filed earlier, Lordship, it appears that there was no record and no retention was there.
But
And
for a confirmed post, where is the scope? Is there retention necessary for a confirmed post?
no, if it, as per the affidavit that I'm going, I'm.
No, we are referring you page 30 of the order.
Yes, Lordship, it appears that it was confirmed.
Let So you examine and pass, you release whatever salaries that pensioner pay.
Yes.
Within a time frame. I give you 90 days to verify and release. Mr. Chauhan,
My lord. Yes, my lord. Yes.
we are closing the matter.
Yes, my lord. Respondent number 5, the director of my lord, education BTC, my lord.
Yes. Right. Bibi Nazari. Yes. Mr. P. Chaudhary for PTC, Mr. P. N. Sharma for education. I suppose we'll pass the order. Thank you.
My please, your lordship. It should be the council of the, from my senior council, lordship. My senior is not present today. Lordship, he likes to start the matter, so I'll take these notes, lordship.
Then let us take it up in the second half. Mr. Saraf. Let us complete the vote. Take it up second. 2 p.m. May not be exactly at 2 p.m. Little after 2.
Like.
May I please, your lordship? The matter pertains to non-payment of arrear salary and retirement benefits. Kindly see order dated 8/5/2024. Respondent number 4 was asked to receive instructions on the current status.
Yes, any instructions there? No counter affidavit.
Lordship, respondent number 4, accountant general was directed. Lordship.
Where is accountant general? Display for.
Yeah. Sometime again, the other council maybe it may look at this case. I'll inform them next week.
You're asking for what? Pension? What is your prayer?
Arrear salary during the period of leave and the retirement benefit, monthly superannuation.
Huh?
Right. Yeah, compared to the.
The petitioner had died during the course of the litigation. His wife was impleaded.
Yes.
Well, earlier councilman Hassan was there. Now he is not there. So, my lord, next week, my lord, I'll inform
But
you.
what is accountant general got to do with it?
Probably the proposal is sent to AAC. Maybe.
Okay, you obtained the instruction?
Yes, my lord.
Mr. S.K. Mehdi, Director, Planning Council, Accountant General will obtain further instructions as to whether proposal for pension in respect of the late husband of the present petitioner was sent by the Department of Health. And if so, the present status, the same. Mr. B. Chaudhary, the Standing Council for the Health Department will also.
Lordship for BTC, I mean.
For BTC. Why BTC is here?
Lordship, he, uh, he was working in the BTC area.
All right. For appearing for the BTC, will also apprise the court as to the status of the pension proposal in respect of the writ petitioner as well as the claim for his claim for area salary. Let the matter be listed after 1 week. It's on 29. Be 1 week. 29.
Okay.
MS Sloan, what is your name?
K. Burman.
K. Burman. Here's the district.
Kindly pass over this matter. Mr. K. Gogoi will appear. He is held up in another court, madam. Pass over the timing.
Require some hearing where he would impress that it's a covered case. I would try to differentiate between the two.
Timing. Again,
Obliged.
Lordship, due to some medical emergency, the standing counsel is not present in the court today. Can this matter be taken up after a week?
No problem.
a prayer is made on behalf of Standing Council Health.
Yes, your lord.
Who is the council?
Deep Bomano.
The government. That's because of medical issue. prayer is made not objected to by Mr. S. Islam. Mr. S. K. Mehdi, accounted. 1 week
Yes, sir.
Can you fix a date here?
is not 31st May.
Lordship, this is a case of irregular and illegal appointment lordship. And the petitioner was supposed to appear before that screening committee. But before the consideration of the case of the petitioner lordship in 2019, the petitioner has attained the age of superannuation. That instruction we received lordship. As a result, he could neither be accommodated as a teacher nor as a tutor lordship. We are going to file our affidavit lordship. We received the instruction.
Bring it on record.
Lordship.
Let them file their affidavit. Mr. P. N. Sharma, Learned Counsel. Submits that instruction have been received by the Your name?
A Hussain. A Hussain.
A. Hussain. Listed after 3 weeks.
Listener.
At the same prayer as
Same prayer. Standing counsel. Not
A date may
available.
be fixed, madam. After
Huh?
2 weeks, madam. A date may be fixed, madam. After 2 weeks, madam.
After 31st.
No. 3rd of June, madam. 3rd or 4th of June.
Okay, 3rd of June.
Much better.
Okay.
Same prayer. Standing counsel.
And for
Sir,
referral,
R.
four.
Guru is for the accountant.
Four. Like
The rest count for it. 3rd of June.
Wait, please, your lord.
Here.
Eh? Traffic must. Traffic must.
Big money.
The request is para 18, my lord, it is summarized.
The Traffic Mashi and Sham Babu Verma,
My lord.
the recovery was not made.
Yes.
In your case, you have already given back the recovery. Now you're asking for
Yeah.
money back.
Yes, sir.
But this money is not, you are not entitled to this money.
No, no, I am entitled to that fund.
How?
Because what happened, this is not my mistake. I did not play any fraud or misrepresentation.
Maybe.
Because it is their mistake. The Honorable Guwahati High Court
But
has.
you have returned back.
Well, not returned, not out of my free will. They have compelled me to return deposit.
You have been compelled, these judgments lay down a ratio that there shall be no recovery.
No recovery is.
But here is a case where the amount has already been recovered.
No recovery
Now
means.
you are seeking a writ to return back that money.
Yes, brother. No recovery means they should not have recovered it.
They should not have.
They should not have recovered it, but they have done it because they have got this power. Once they stop my pension.
So therefore, you are before the court seeking a direction to return back that money.
Yes, sir.
To seek a direction, to seek a writ, you must establish your right. What is your right to get back that money?
Right means I am paid it throughout 3 decades. I am paying that amount.
Is that amount correctly calculated to be your salary?
It is coming with my salary, my lord.
It is your claim that this amount was excess paid to you.
Excess paid because it is not due to my fault.
Exactly, may not be to your fault.
No.
But before you
it was part of my payment. I enjoyed it and I was paid for it. It was paid to me also. But after payment, it was.
Then you have to question the very decision of the authority that it was excess payment.
No. It was. I did not concede that it is excess payment because it was paid to me due to their own mistake. And Honorable Guwahati High Court has.
Considering that it is a mistake under which you have received the amount.
Yeah.
Then you will have to contest the very.
This is all the Guwahati High Court has got some other judgment also.
All the judgments are prior to release, prior to recovery. You are now before the court. The amount having been recovered. It is already with the government.
During the continuance of the service, most of them, because I was paid the amount, retirement benefit was paid to me.
Mr. Counsel, you are not understanding your. What is your prayer in the You are directing them to refund the amount. You are asking for a mandamus to refund the amount. This is your prayer, page number 14.
Yeah.
And you know for a mandamus, you must establish your right. You establish the right.
Because that is whatever I have been paid, being a grade 3 employee, because it will cause great hardship to me because it is already.
Hardship or not hardship, you must satisfy that this amount for which you are now seeking a mandamus rightfully belongs to you and it was wrongly recovered.
Yes, it rightly belongs to me because it was in due course of this payment. Salary was calculated by them. They paid me years after years. I enjoyed it. I took it as part of my life that this amount is coming to my life, coming to my the daily life. Otherwise, also the family is also enjoying all this benefit. But suddenly they wanted me to return it. So once they have paid to me as retirement benefit, they have forced me to return it, to deposit it again. And for that reason, I have come to the Honorable Court. Lokesh sir, I beg to rely on Lokesh sir versus Lokesh sir, the State of Assam State Assam Electricity Board.
Let us see.
Here. My lord, para 11. Para 11. The rival submissions have been noticed. First and foremost, the issue as to whether the alleged excess salary drawn by the petitioner can be recovered or not is an issue which is no more res integra. The decisions relied upon by the council, the common thread is that recovery would not be permissible in law, particularly in respect of the employees belonging to class 3 and class 4 service. Admittedly, on the date of retirement of the petitioner, the petitioner was serving as a class 3 employee under the respondent authority. The apex court in the case of state of Punjab, this is Rafiq Mas's case, has held that the right to recover would be maintainable so long as the same is not arbitrary or inequitable. The element of extreme hardship that may visit an employee in case of recovery has also been noted by the apex court. In that context, it was held that the recovery from employees belonging to lower rank of service should not be ordinarily affected by subjecting the employee to the vagaries of life.
Yes.
Because I am a grade 3 employee, for that reason the amount is not so huge amount, but still it is for me, it is a very huge amount for me, not the state of Assam or the government or the other institution. For that reason, that amount should not be taken back from me.
That amount should not be taken back, we agree, but it was already taken back.
It should be returned by them.
No, it cannot be. Unless you explain that this is an amount that belongs to you, your right has been infringed.
It belongs to me, for that reason I was paid.
You are paid, but you admit that this is excess payment.
No, not the excess payment. This all the husbands are telling that if it is wrong calculation,
Wrong calculation at the time of recovery, you have judgments in your favor. Here is a case where the recovery has already been made.
Recovery, but this is under compulsion. I have just deposited. It is not out of.
Now you're asking it. To say that this amount belongs. Now you have to say that this amount belongs to you, and there is no wrong calculation. You satisfy the court on that.
Because the judgments are there. The judgments are there.
Judgments are decisions rendered on the facts of each case.
Same fact, because this is they wrongly recorded.
It is not the same fact.
They wrongly fixed the salary.
Maybe, but the amount was not recovered. In your case, the amount was recovered. You are asking for
recovered means they have even asked notices to me.
Maybe, but you have given back the amount.
Once on the basis of the notice I have returned.
No. You have not been able to satisfy it. Your only claim that you can make now is to show that this was not wrong calculation. This was actually due to you.
Not at all. This is not, neither there was any misrepresentation of fact, nor any fraud played by me. For that reason, how can I be responsible for it?
Then you produce your relevant scale of pay or whatever is there. In all these, even in this matter, there was an order for recovery. The amount was not recovered. All these cases are on the principle that even if it is a wrong calculation, amount has been released, don't recover from somebody who's in grade 3, grade 4, retired. Don't do it. Here is a case where you have voluntarily given it back.
Not voluntarily, my lord, not at all voluntarily. The records are there that I was directed to pay by the commandant.
But you paid it.
Paid, I must pay it, otherwise they are going to withhold my pension.
So perhaps you should have been before the court prior to making this payment.
Because I made it sincerely, because the once they wanted, I did it, and thereafter I have come to the
now before the court asking for a refund. For a refund, you must establish that you have a right to get back that.
I have got every right.
That you'll have to satisfy the court on the ground that there is no miscalculation.
This
amount was wrongly recovered or asked, or you're compelled to give that amount back.
It was paid me because the authorities considered it that it is due to me. I am entitled to it. Thereafter, they just discovered their fault.
You tell us the scale of pay.
Scale of pay is there. Page 27.
Where is the scale of pay?
Scale of pay, it is 542. It should have been, but it was fixed at 554.
You tell us that 554 is the correct scale of pay.
Because they fixed it, because I did not have any hand there at that time.
I know you
Even
don't have
later
a hand,
also.
but you have access to, you can have access to the scale of pay to find out what is your exact scale of pay. This is as per the ROP.
Because I was not concerned with it because the authority was.
Of course, you are concerned. Now you are filing a writ asking for a refund.
Because
You
they have
to be
paid me
concerned.
throughout all these 3 decades, they are paying me this, the revised pay also they have paid.
But whether you are entitled to that scale of
Entitled, I'm entitled, once they have fixed it, I'm entitled.
No, it show us, it can always be corrected.
No.
You have to show us that you are entitled to this scale of pay. Okay. Yes, Mr. Accountant General, you show us what is the correct scale of pay.
Well, this
Why you was allowed, why you have given this pay for such a long time? How it came to be over?
the letter, the just this page 26 and 26, the dear letter, my lord, Assam Police letter, my lord, and after page 27, my lord. When the pension was fixed, my lord, that at that time, my lord, the pension return of the pension case in respect to so, my lord. The next part, the fixing the pay of ROP 83 so and so 554, which effect from is not found in order. This is the case of appointment of 11
Page number
27, my lord.
So that's what
Yes, ma'am.
you have to show us that 542 is the correct scale of pay and not 540, 554.
Yes. This case, my lord, this would not file affidavit, my lord. So for that, my lord, if I have to take my lord further instruction, my lord.
You get it?
But here, my lord, we have to come only for this the letter to the additional director general of police, my lord. There is excess drawal of pay and allowances, my lord, leave salary, my lord. And petition was given the letter on 9th January 2018, my lord. And thereafter, my lord, they themselves voluntarily deposited the amount, my lord, 21st April 2018, my lord. 2018, they done. Then the petition is filed by 2021, my lord, after more than 3 years, my lord. There is no protest, my lord, against the letter, page 27, my lord, the AG letter, my lord.
How can it pay?
Because
He's an employee.
because it was sent to them, him also, my lord. This copy also he received, my lord.
To have minimum scale of he is drawing that salary.
That is true, my lord.
After retirement or prior to
That is
retirement, it depends that we are
that-
giving him more money.
That is true, my lord. Yes, my lord, that is true. But where here, Rofik Masih's case, my lord, this says, my lord, this paragraph 18, the last, my lord, paragraph Roman 4, Roman 5, in any other case where the court arrives at the conclusion that the recovery is made from employer would be iniquitous and harass or arbitrary to such an extent as would far weighted the equitable balance of the employer's the right to recover. And there is, my lord, because of he himself, my lord, they deposited in 2018, my lord, and representation was filed 2021, my lord. And after that, this representation was filed, my lord, because if there is anything, my lord, even this, there should be any letter from the representative to the authority, my lord. Now he is not able to deposit the amount because of financial condition as per this judgment, my lord. That was not there, my lord. Only he voluntarily deposited this amount, my lord. Now after 3 years, my lord, my lord, he found the petition filed this petition, my lord.
That was deposited, my lord. It was deposited by himself by the petitioner, my lord, in 2018 April. And the writ petition was filed, my lord, 2021 December, my lord. After more than 3 years, my lord. And there is only one letter annexed, my lord, page 28, this calculation of the commandant, my lord. And this also, my lord, page 28, my lord, the last line, the overdrawn payment so-and-so and leave salaries should be deposited. There is no, only should be deposited. There is no direction to deposit.
Pointed out the error, the accountant general.
Yes, ma'am. I'll, in this regard, my lord, so for pay scale, my lord, I'll check, my lord.
Your lordship, if I may, speak, um,
Yes.
Well,
what do you have to submit?
Your lordship, this present case is clearly distinguishes from the Rafiq Masih case. Why I tell your lordship? Because in the Rafiq Masih case, all those recoveries, all the petitioners in those cases, they approach the court prior to recovery. Once recovery notice, just like the similar at page number 27.
That we have already achieved.
Yes, and
anything beyond that.
your lordship, in that case, your lordship, he should have approached the your lordship.
He
In
should have,
and
done that, I agree.
And
He's an employee of the department. He was given,
totally agree.
He was given to believe that his salary he was drawing in, but at the end he was asked to return to the
And here, nobody forced him. We have stated specifically in our affidavit.
You don't force him, you return him the money back.
No, your lordship, why? Because he cannot appropriate and reprobate at the same time. Because here he had deposited out of his own volition. After deposit, he simply cannot later on come and say, no, I have deposited, because this is all an afterthought. Because if he actually deposited out of our pressure, the department's pressure.
Is there any undertaking? Note that he is doing it out of his own.
Your lordship, to that effect, there is no such undertaking. At the same time, there is no such letter annexed by the petition in his writ petition that we had actually asked him to deposit it.
No, because you have issued a letter asking him to return that amount.
Yes, that's why I have stated, your lordship, he should have approached your lordship earlier.
So he should have approached.
But he did not.
Approach. The
Then,
question is, who is responsible for this miscalculation and this consequential litigation? Who is responsible?
Now, coming to that particular
why shouldn't the
question.
department be saddled with some responsibility to be more cautious while deciding the scale of pay?
Your lordship, coming to that
Why should
particular
the
issue.
department be allowed to get away by causing this kind of harassment to the citizen?
Your lordship, to that particular question, your lordship, if I may take your lordship to that paragraph number 5 of the principle number 5 of Rafiq Masih's judgment. Here, a particular balance has to be maintained with regards to the petitioner's, the department's right to recovery, and at the same time, the harshness and iniquitousness which the petitioner might face due to such recovery. So balance has to be maintained. Here, the balance
It is for the court.
Yes.
We are asking the query to the counsel of the department.
Yes,
that
your
why
lordship.
the department should be let off for making a calculation, giving him a higher salary, and at the fag end of his career, you force him to part with his salary, which he believes that it was his salary.
Your lordship, if I may state in that particular respect, I would have totally agreed to your lordship had he actually approached the lordship prior to this recovery.
For us, you leave it for us to decide. You answer the query put by the court. You tell us why the department, who is responsible in the department to have wrongly fixed his salary. For how many years have you worked? How many years?
33 years.
33 years.
Your lordship,
Nobody in the department is accountable.
your lordship,
That a man has been given a wrong salary in the wrong scale of pay.
here, your lordship, if I take your lordship to page number 345 of the judgment at Placitum B. Here,
You are harping on the judgment.
No,
We are
no, your
asking
lordship.
you questions of facts,
it is,
which is not available in the judgment.
your lordship, I totally agree, because here
So if
in
you
that
agree, you give us the answer.
particular mistake might have crept in due to many other factors, many factors, and that's why the Supreme Court actually observed that
Many factors.
after
Don't
so
be-
many
don't
years.
Don't give us these evasive answers. What was the reason? Why, on whose basis this error had occurred? You tell us. Let us find out.
That I have to seek instructions.
You
Your
seek
Lordship,
your instructions and
as to why that,
clarify as to why his scale of pay was fixed at whose instance and who is responsible.
who's responsible.
We'll direct this amount to be recovered from those hearing officers.
Yeah, yeah.
You give us
Yes,
the
Your Lordship.
information by the next day
Yes.
and positively.
Yes.
The respondent state council will apprise the court as to how the scale of pay of the petitioner came to be wrongly fixed during his entire period of service of how many years?
33 years.
33 years. Scale of pay ought to have been 542 per month, but it was instead fixed at 554 per month. And as a consequence thereof, when did you return the amount? After retirement.
After.
And pursuant to his superannuation, he was compelled to return an amount of rupees
3 lakh, 24,974.
3,24,974,
974.
which was recovered by the department as being excess amount paid to him in order to settle his debt. Mr. S.K. Medi, the standing counsel, accountant general will also apprise the court as to the appropriate scale of pay payable to the Mr. Alap, the counsel, will also be matter will be listed again on
5th of May, June,
31st. 31st.
third of June.
No, why? 31st. 31st May. Yes. Who has placed the judgment? 1986 4 SCC.
Lordship, me.
This is in response to alternative remedy.
No.
Then
Lordship will come to paragraph 5. The Lordship, I have made it bold. It is an accepted principle that in public service, transfer is an incident of service. It is also an implied condition of service and appointing authority has wide discretion in the matter. The government is the best judge to decide how to distribute and utilize the services of its employees. However, this power must be exercised honestly, bona fide, and reasonably. It should be exercised in public interest. If the exercise of power is based on extraneous conditions or for achieving an alien purpose or an oblique motive, it would amount to malafide and colorable exercise of power. Frequent transfers without sufficient reasons to justify such transfers cannot but be held as in fight. A transfer is malafide when it is made not for the professed purpose, such as in normal course or in public or administrative interest, or in the exigencies of service, but for other purpose, that is to accommodate another person for undisclosed reason. This is the basic principle of rule of law and the good administration. And even administrative actions should be just and fair. Now, in the instant case, if at all the records are to be taken into consideration, the government side has placed the records, they say that there are complaints. If there are complaints, Lordship,
Why not a departmental proceeding against me? There cannot be a punitive transfer. And Lordship has also seen there is an application from the mother of the private respondent. And the submission made on the other day was to accommodate him, the transfer was made. If to accommodate him, transfer is made, Lordship, why not my application has been considered? I also said that I want to stay in that place. I have not been in that place for 1 year. Before 1 year, I have been transferred out. This has again, Lordship, been followed in 2019-13 SCC 788. The same principle which has been quoted.
Even the cited.
This is Lordship 2019-13 SCC 788. Uh,
2019, 13.
19-13 SCC 788. I'll give a copy of this now. Sorry. I'll just read out, Lordship. In the earlier judgment, Lordship, this 788 in paragraph 5 says, it is no doubt true that the power of transfer is abused. The exercise of power is vitiated. But it is one thing to say that the order of transfer which is not made in public interest, but for collateral purpose with the oblique motives is vitiated by abuse of power. And an altogether different thing to say that such an order per se made in the exigencies of service varies any condition of service express or implied to the disadvantage of the government servant. Lordship, that part I would accept. It might be to my disadvantage. But what was the consideration that was taken into account?
Where do you find the reference that it was made to accommodate the private respondent?
Lordship, the other day, it was in the record. They have
Where are
said
the record?
Never.
that an application was made by the mother of the.
Yesterday, Your Lordship, I placed the record and Your
We asked
Lordship,
you to give us the photocopy.
photocopy has been given, Your Lordship. Your Lordship may take the original. That would be convenient. The photocopy to move. Photocopy.
Where is the government notification 9 September?
It is in an affidavit filed by respondent number 4. Page number 26, Annex 1. Page number 26, Annex 1.
One affidavit by respondent 2.
Respondent 2 and respondent number
This
4.
is filed in the IA, Lordship, the affidavit.
In IA number 3145 of 2023.
I.
IA.
Correspondent number 4. Where is the
This gives the power to the deputy commissioner to,
the notification?
Yes. Because that is also one of the grounds which has been raised by the petitioner as to how the deputy commissioner could transfer the petition.
Your what staff? Grade 3.
breaks.
Grade 3. Better delivery of it.
Now, because lordship this notification, the only stand which I can see that has been taken from the side of the state is, one is the complaint. One is the complaint. And the second is there was a representation made by the mother. In so far as the complaint is concerned, lordship, if I may take your lordship, I will just refer to one judgment of the Supreme Court in 2009 to SCC 592. I'll just like to read out 2 paragraphs from there.
The third person is not before the.
He has already joined in Fekaman. So now the post of South Salmana is lying vacant. Because the third person, Abu Hanif Mokadimo, he has already joined in Fekumari. The private respondent, he is lying in the hanging in the balance because of the pay order. He cannot join in Mankasar because the petitioner is there in Mankasar. The public interest is actually being affected here. That's what.
Who is the petitioner?
Abdul Mumin Sarkar. Abdul Mumin Sarkar.
That is number 2 in the impugned order, lordship.
So between petitioner and private respondent, your places are interchanged.
Yeah. No, your lordship.
Posted to South Salmana where?
The petitioner was posted from Mankasar to South Salmana.
South Salmana where?
South Salmana ICDS project. South Salmana, within this South Salmana district there are 3 ICDS projects. Thekamari, Mankasar and South Salmana.
Where is South Salmana? That's what I'm asking. Is it in Thekamari or Man?
No, it's in South Salmana district itself, within the district.
I know it is within the district.
Exactly.
That one is Fulbari.
Huh?
I think Fulbari, the Meghalaya Fulbari, and from that to 1 kilometer ahead.
But it is the district.
Yes.
End
That
of
is-
the day, it is the
Yes.
That,
No advert.
I'm not disputing that. What my submission before your lordship is, when I had filed my application, I was of the view there were 3 transfer orders. In fact, after the government, that too after many days, the government came and said that the middle transfer order, there is no such order of July. If there is no such order of July, how the impugned order can be passed? An order,
impugned order is 14 September.
impugned order is in 14 September. Now they say there is no order of 17 July. So if there is no order of 17 July, how the 17th order July order can be modified? It cannot be modified. This particular impugned order has got no legs to stand on.
Where does it refer to?
Now, they say that they have prepared a draft.
In partial modification.
Yes, they have prepared a draft which was never finalized. Now, a draft cannot be modified to mean a final order. That cannot be. I do not have any difficulty. But if at all,
Order, impugned order saying that party application, earlier order.
That order does
That
not
order
exist.
Does not exist.
17 July never existed at all.
But it is found in the recycle order.
It is found in the recital, but that particular 17, yes, 17 July was signed on 14 July. Then the 14 September, I'm sorry. And that is reflected in the 17 July order. itself. If your lordship goes to the, if the,
We get decision in 17 July. Why 24 September pass the order giving exigencies of officer?
that I believe the instruction, they have explained in the written instruction.
What is there? You have the hot copy.
No, your lordship.
You read it out. But
Sir, the transfer order number so and so was put up on 17/7/2023 and signed on 14/9/23 at 2:19 PM in XSC. The order has 17/7/2023 as date at the head and 14/9/2023 at the signature part of the order. It is noteworthy to mention that in e-office portal, digitized filing system, when a file is processed, the put up date and the disposal date reflects automatically in the order to maintain the time stamp stack of file movement. Here, your lordship, in this particular, here, the note sheet, that digitized note sheet is attached, your lordship. As to from 17/7, how it was actually moved from one of place to another. one
17/7,
table
there was no order, lordship. A draft is not an order.
who is Mahmoud Al Hassan?
Mahmoud Al Hassan,
Respondent number 5.
respondent of 5, private respondent. Pekamari to Mankasa, the one who was transferred.
This note reflects that transfer order was prepared as prayer.
As a prayer petition. It was mentioned, but at the end of the day, that's why after on 14 September 2023, it was changed. The lordship to take into consideration because there is the third person, this Sri Abu Hanif Mokadimo Sardar. He was transferred from South Salamar to Phegamari. So because the petitioner, he was earlier posted in Phegamari. From Phegamari, he was transferred to.
We are not concerned of the A post or B. We want to know why this confusion and anything.
Your lordship may direct the DC to decide on this particular issue because the one post is actually lying vacant because of the stay order. So at the earliest, the DC can decide and direct the person considering his prayer because he says that his representation is pending.
There is no difficulty, only lordship. So far as if a DC takes a fresh call, lordship, I have got no difficulty at all. But a transfer order cannot be on the basis of some complaints against me. If it is punitive, lordship, no transfer order.
Lordship, it is not at this stage. We cannot say it is punitive.
No,
Your
that
lordship,
is what
because the
they
transfer
rely
order
upon.
doesn't reflect it.
People know
They rely upon some complaint.
was prepared as application by some.
And
If that is
that
to
was not
accommodate
his
that, it is
transfer.
bona fide,
If
lordship.
your lordship
As
has
per the
to go by the
Supreme Court.
note sheet also, that transfer was not on the basis of the application filed by the public. It was based on the application filed by the mother of the private
That is also
respondent,
bona fide as per Supreme Court,
considering the age of the parents of the private respondent of 5. That was not based on transfer, was not based on complaint. The complaint which was against the petitioner.
Okay, we are remanding it back to the DC. Let him decide, because this order originated from and it resulted in some confusion. So let the decision be taken by the authority.
Independent of any representation of it.
But we are disposing of the IA as well as the. Yes, but
Page 22.
14 September. Okay, by another. Where transfer the petition working as what?
Statistical assistant.
The statistical assistant. The office of the CDPO was initially appointed in the office of CDPO Vilasima, ICDS. The year in on 29th and he accordingly joined the same office. Having worked there for 2 months, was transferred to Hailagandi by the order dated 3/9. Subsequent there, petitioner was transferred to state. The ICDS protected Kaman outside by the order dated 10/6/2000. So since 16/6/2000, they joined it posted in Tekamati ICDS. On 15/10/2020, petitioner was again transferred from Tekamari ICDS project to Manpachar ICDS. Petitioner being aggrieved so challenging the order dated 14/9/2020. By the said order, the petitioner was transferred from Manpachar ICDS project South Salmara. The incumbent in South Salmara ICDS project, namely one Sri Abu Hanif Mokadimo Pratap, was transferred to Tekamari ICDS, and the private respondent was posted in Tekamari ICDS. Being aggrieved, the council for the that a bare perusal of this order reflects that there was an earlier order issued on 17 July and which was modified, and thereafter the new order dated 49. They submit that the earlier order dated 17 July 2023 was never served on the writ petition, and the best of the knowledge of the writ, the said order was modified, and the new order was for regions which are not germane to public service. It is submitted that since his date of appointment, the petitioner has been transferred very frequently. Without proper petitioner has accepted of the transfer. However, within a period of less than 1 year, petitioner is again announced of the transfer. It is submitted by the current government that although transfer is a residence, however, the employer must not use power of transfer for reasons which are not in support of public service and which are not and which are contrary to the guidelines and the procedure of and thereby making it nullified. It is further submitted by the current government that the best of his knowledge is transfer as initiated by the district committee at the instance of the private respondent. And therefore, in order to accommodate the private respondent, the order in night. That being the position, the due order cannot be said to be an order issued by the employer. Therefore, that extent, same is contrary to the law of traffic and therefore required to pay. Anything else? Yeah. Let's go by issuing notice by order dated 27/9/2020. Granted. Let's take it. Directed status quo will be maintained in the next day. The status quo which was issued came to the extent and is present still in. Pursuant to the status quo, petitioner continued in present case. Dekamari IC, South Salman. The private respondent being aggrieved by the status quo filed an IA taking vacation of status quo order. The learned counsel hearing for the private respondent and also the applicant in the IA that the potential of the frequent not borne out by the report extent private respondent is informed. And furthermore, because of the ex parte order and because the fact that third person who had also been transferred by the impute order in 49 when we had already joined in the place of the applicant. Presently, the applicant has no place to join, and it's therefore therefore does not have a place to stay. Therefore, submits that the order indicated, and the applicant should be allowed to join in the place of staying, which is South Salmona district, South Salmona Manipur district, and in which post the present petition presently being posted by virtue of mistake. Any affidavit filed by the department? Affidavit.
Respond number 2 and 4, 4 has filed in the I, respond number 2 has filed in the writ petition.
The department has filed their respective as well as the PID. And it's that the DC is the competent authority transfer all employees belonging to Great Indian Railway from one place to another within the same district and the same department in consultation with the district head, the concerned party, for better delivery. And the same was and the impugned order and the order which is impugned in the writ petition also issued. Therefore, there is no infirmity in the order dated 49 and therefore the claim of the writ petition in the order is the same. The director by the I
Director has filed in the affidavit, in the writ petition.
director is filed the writ petition and the respondent number 4 additional is by the director by submit that the writ petitioner was posted in South Salmana for several years, and that about there are several complaints received against. Furthermore, the director in his affidavit submits that in terms of notification dated 9/9/2025, Deputy Commissioner of all districts, excluding 6U districts, are empowered to transfer grade 3 and grade 4 staff of all heads to one place per annum. And same department, consultation with the district head of the concerned line. Since the affidavit filed with the department does not satisfy the concerned reports pertaining to the transfer scoreboard, and that these reports were placed before the court. And from the reports, what is seen is that although the impugned order dated 49/2023, 23 is
Yes, sir. Yes.
23, reflects that the said order is a modification of an earlier order dated 17 July. The record revealed that there was no order dated 17 July 2023 transferring the petitioner or the private order ever issued by the department. On the other hand, what is noted is that there are complaints filed against the writ petition as well as the private respondent by a section of local 12 people. The latter part, the mother of the private respondent had filed an application which was placed before the concerned authority, requesting the authority to transfer the private respondent from Tekamari ICPS to Mankachar ICPS as the mother of the petitioner is suffering from health issue. Mother as well as the father of the petitioner are suffering from health issue. So this application was placed to the concerned authority, and from the office record seen that the transfer order was prepared for the statistical assistant of ICTS projects of Mankachar and Tekamari as per the prayer petition of the private respondent, namely prayer petition issued by mother. So the learned government advocate clarified that there was no transfer order issued on 7/7/2023. Rather, the transfer order was prepared and placed before the competent authority 17/7/2020, and which transfer order subsequently came to be notified issue on 14/9. Where having heard the private submission and reading on you see that the records contain complaint petition filed by local residents against both the as well as private respondents. But as on date, no inquiry or any department of things have been initiated by the department against either of them. While there is no dispute, there is no quarrel with the proposition that the employer within its right to transfer an employee in exigencies of exigencies of so the fact remains that the order of transfer has to be issued by the competent authority upon being seized of all relevant materials, facts, and circumstances. So, the record revealed that transfer order, the initiation of the transfer order on the basis of an application prepared by the private respondent mother. Such initiation, although prima facie cannot be termed relevant, but it also not be considered to be in exigencies of public. So, if the authorities want to consider prayer of the private respondent on humanitarian grounds or any other personal ground, then they are within their rights to pass effective orders. However, subject to the rights of other corresponding officers not being interfered. So, this is not transfer on mutual consent by an consequently, this court of the considered view that the manner in which the transfer order is initiated does not inspire confidence that same must be the light of exigency of the public. Prima facie evidence that transfer order was issued to accommodate private response. So, whether the authorities are competent or are empowered to do so is a question which is required to be decided by the authorities concerned. But on the facts and materials and after due examination of the relevant report, it cannot be held that this transfer order was issued in evidence of public, at least insofar as the practice. This context, the reference may be made referred to and relied upon by counsel rather than B. Varadha Rao, reported in 1984 as the apex court in the judgment, while dealing with transfer order, held that the power to transfer equity in a transferable goods is unquestioned, but this power has to be exercised nothing with the evidence. If the power is exercised melaping, and then the order of transfer is liable. Here, in view of the discussion held above, since this court is of the considered the transfer order, is not exercised bona fide exercise which the matter is not in fact we decide and upon considering the matter that we could pass if such a decision taken by upon taking the interim or status quo path direct path
2 weeks, within 2 weeks.
3 weeks of the date of if such status quo yes writ petition and I dispose of.
Not in one place where the lordship has dictated, the petitioner sought for joining in his respective place in South Salman, not in South Salman, to Mankasar. It may be Mankasar.
Yes.
Obliged.
People lordship will both are decide lordship any other day.
Lordship, regarding the payment of risk allowance to a civilian employee in the CRPF, for the time he served,
Lordship.
Reading the
yes,
so here no
Today, yes, sir.
it's the reading the complete matter
lordship can say,
also
mine.
Lordship.
I'm obliged.
Letter to heart. Anyway, my lord.
why was it deferred?
Arguments could not be concluded, my lord. Item 46, my lord, I am appearing. Here, my lord, the petitioner, while serving as 2IC in the CRPF, my lord, his SCF were reviewed and accepted by the same authority, and the appeal filed by him also was disposed by the same authority, seizure to seizure matter. May I straight away place the HAF, my lord.
where is that order that he is not entitled to that uh, incentive because he does not have that.
No, no. Here, my lord, I was downgraded. And because of that downgradation, when the departmental promotion committee met, I was found to be unfit, my lord. But you will kindly allow me to place the ACR, my lord.
Yes.
Lordship will kindly come to page number 47 of the writ petition, 47.
47.
Yes. Yes. Lordship, grading by the reporting officer, very good. Then grading by the reviewing officer has been good. Lordship, kindly mark the date. It is 2/8/2011.
Hmm.
Then accepting officer, next page, my lord. Graded as good. Same officer, my lord, same authority, and the document kindly mark the date. Now, accepting officer accept, my lord, on 1/8/2011.
No, this is very good.
Yes.
Very good is given on which date? 18/4.
Yes.
18/4.
Yes, my lord.
Okay. Reviewing officer does it on 2/11.
2/11 and accepting officer on 1/8/11. It cannot be, my lord.
Maybe on the same date.
But in their affidavit official, they have not taken that. It's an adversarial litigation, my lord. I have been found to be unfit because of this downgrading. And I preferred an appeal. Lordship will kindly, before that, Lordship will kindly come to page number. There is a standing order in CRPF, as your Lordship knows. The standing order starts at page 51, 51. He was even not authorized, my lord, without jurisdiction. Page 51. Lordship will, the operative portion is at page 54. 54. Initiation and maintenance of ACS, down below your Lordship got it. I'll just read, my lord. The procedure for initiation and maintenance of ACS of officers as outlined below is laid down. The ACS will be initiated in duplicate by this commandant, principal, AITG, being the controlling officers of the respective unit, establishment, institution, as the case may be. The admin ACR will be sent to range DIG and the operational ACR to the operational DIG. The range and operational DIG, after considering their remarks, will forward both the copies of to the admin IGP. The operational IGP at the end of the year may, if need be, forward his appreciation impression, any worthwhile achievement, misconduct, or slackness, etc., in the performance of any officer in writing to the administration IGP, who in turn would take this into account while endorsing the SCRS. So the administration IGP is the accepting authority as per their own office memorandum. And in my case, it is the, my lord, will kindly turn to page 48. Signature of the accepting authority, Inspector General of Police Operations. He acted without jurisdiction, my lord.
What is there any stand that the admin IGP was not available?
No, no stand, my lord, no stand. And thereafter, I preferred an appeal. Lordship will kindly turn to page.
The person who was the reporting accepting officer was Ops.
Operational, yes, yes.
Here, I would like to submit something before your lordship proceed. Now, my lord, this case was initially looked after by SKMT. Thereafter, then its Solicitor General has appeared. Now, just an hour back, these two files has been handed over to. Just an hour back. These files have been handed over. My lord, is it possible to fix this matter on Monday? Monday, we will do the hearing. I will do the
That is the submission you are expected to make before the hearing starts. Why were you waiting to make the submission? Or you thought the court somehow be aware that it was handed over 1 hour back.
No, definitely, court is not going, has to be aware.
All right, we'll accommodate you, not a problem.
My lord, on Monday.
Keep it on a hearing day because it will require some hearing.
Then, my lord, you said
Tuesday,
next Tuesday. Deeply obliged, ma'am. Tuesday open?
Tuesday,
Tuesday.
it is submitted by the settlement CGC
CGC.
that brief has been handed over to him. They therefore not pay the short. Again on Tuesday.
Tuesday, my lord. Tuesday.
Tuesday is 21st. Instead of 21st, can it be on 28th, my lord? 21st, I have some.
Not 28. It's not 28. It's
That is it.
Patwari.
Later.
We're appearing for
Petition for the other item.
for the other.
Deeply obliged.
May I please, Lordship? Lordship, earlier, last occasion, Lordship, for directed instruction, Lordship. That instruction is awaited, Lordship. It's another day, Lordship.
What instruction?
Lordship, regarding his pension and other retirement benefits, Lordship. Hard appeal, Lordship, it was directed.
You are directed to call for the record.
Lordship, we have to receive, Lordship.
Mr. Property Learned Captain Advocate submit the record. Or you have called for, or you have not called.
Lordship, call for, Lordship.
I've called for, but it's not been received.
As because of election, Lordship.
That will be listed after photo.
Can it be on the 13th of June?
13th.
13th June, if possible, Lord.
14th of June.
Lordship.
Let it be on hearing day, Lordship. I am not getting my pension, Lordship. That's why, Lordship.
Sorry, 13th, yes.
13th.
13th of June.
Obliged,
13th of
Obliged.
Mr. D. Bhattacharya for record.
May I make a prayer? My name may be shown in the caucus.
You know, you fix a date. We have already fixed a date. You note it in your diary. Please note 13th.
Obliged.
Yes.
I can take 7.
What are these matters?
Lordship, before senior counsel, sir, he may complete his part, Lordship may accommodate me for that.
What are these matters? Any affidavit to be filed?
Lordship, in some of the cases, we have filed our.
No more affidavit.
Almost similar.
For eligibility certificate.
Now, there are two types of cases, madam. First set is the rejection of the eligibility certificate. And second set is that on the basis of the rejection of the eligibility certificate, the assessment has been made and the tax demand has been made. Now, my lord, if you also just looks into the, I think, 14, the last order, my lord, which has been passed for rejection. Wonderful.
87.
My lord. Huh? No, it is on estimate, my lord. That's the PSK claim.
Ask.
I've had this one, very fresh.
7-9.
My lord, in fact, what has happened, my lord? My lord, the petitioner established the industry unit, and thereafter, my lord, page 186, 186, my lord. 186.
You are addressing in 188.
My lord, item 188, no? My lord, 5917,
591.
item 14.
Yes.
186, you know?
You are referring to which page?
Page 186. Hmm? It is 7 okay, okay. 186. Page 186, you know? Peruse the Honorable Guwahati High Court order dated so and so, directing the Industry and Commerce Department to resolve the dispute and with regard to the date on which the industry was set up and commence the commercial production. Peruse the entrepreneur's memorandum number so dated so by so wherein the date of commencement of commercial production is indicated at 21/10/2009. Peruse the General Manager District Industry Center Committee Center, that is so wherein the status of the unit is indicated as non-functioning. Peruse the minutes of the state level committee meeting under industrial policy of 2008 held also wherein the commissioner decided to reject the application of the unit for eligible certificate and directed the Commissioner Industry and Commerce Department to issue a speaking order in this regard and apprise the Honorable Guwahati High Court. Government provides tax incentive exemptions and physical incentives to encourage industrial units for their contribution to the economic development of the state in general and employment general in particular. However, a non-functioning unit neither contributes in economic development or employment generation. In view of the above, the petitioner's financial industry found to be ineligible for grant of eligibility under the national policy of financial and the application is rejected. Issue is that, my lord, under the industrial policy, a industrial unit, new unit, which has been established under 2008 industrial policy, new unit and industry undertaking expansion will be entitled to the exemption benefits under this policy for the period of 7 years. Now, I established the industry unit in the commercial production in the year 2009. Now, I was doing my production and business and all those things. In the meantime, as you also have a Rule 57A came under the Assam VAT Act, whereby the manufacturer, it was said that conversion of coal into coke will not be manufactured. The variety of the same was challenged before this Honorable Court, and the region bench held declared the same to be ultra virus. Now, my application, because it was said to be not manufactured, and as such the eligibility was not there. Thereafter, in 17, there was a ban on the coal, my lord, in the Meghalaya NGT coal ban was there. I issued a communication that since there is a ban on the coal, and as such, the factory cannot be functioning, and only after the ban is lifted, then only the factory can be functioning. The division bench also directed them because they said a dispute about the date of commencement of the commercial production that was verified, and it was said to be 2009. Now they have rejected my eligibility certificate only on the ground that on the day of the visit, the unit was not functioning. Now, there is no provision in the policy or anywhere that the unit must continue to remain functioning all the time for 7 years, 10 years, 8 years, and then only the eligibility certificate will be issued. Because the reason is that, my lord, that assuming, my lord, I establish an industrial unit and there is no controversy, I get an eligibility certificate from them. 5 years, I get an exemption. After 5 years, I closed down my industry unit. Whether there is any provision that if I close down after 5 years, whatever benefit was given for prior to 5 years will be recovered. There is no provision. There is no provision in the scheme or policy that the unit must continue to operate for the time for the industrial development, then only the exemption will be given. There is no such provision. Since there is no such provision,
Exemption for the period which were
my lord, I have claimed for the.
you are not claiming for the period.
No, not at all. Now they are saying that the exemption was intention was for industrial development labor, and since you are not operating now, so the exemption, the purpose is not fulfilled. Thereby, the exemption will not be granted. Now, my lord, for that, either in the policy or somewhere it must be mentioned that the exemption will be available only after completion of the period of 7 years, or not only 7 years. For 15 years, you must continue. You cannot close down. Then only exemption will be available. There is no such provision is there. There is no such things are there. Because the exemption is for 7 years only, my lord. After 7 years, there is nothing. I will not get exemption. I can close down. Exemption is also limited to the 150% or 100% of the total capital investment. Assuming after in 1 year, I meet, my production is so high that the entire limit is met and nothing remains for exemption. From 2nd years onwards, I have to pay the tax. 3rd year, I close down. Whether the department or government is going to recover the amount which I availed in the 1st year by way of exemption? No. If that is so, then how it can be said that the person who was not giving an eligibility certificate because of the litigation which was going on in the court, and the court provision bench directed that he verify the date of commencement of the production, which was done, and after verifying the date of commencement of the commercial production, the petitioner is claiming the exemption only in respect of the period in which it was operating, and that is within a period of 7 years. From this issue, because there is no provision like this in the industrial policy, there is no provision in the incentive scheme. There is no provision under the like the transport subsidy scheme, which is framed after the industrial policy, capital subsidy scheme, which is framed into the industrial policy, and that is industrial policy of the government of India. But the issues came up before this honorable court also, as well as before the Tripura High Court also, that whether an industry has to run for the entire period for getting the benefit. And both the courts have said, my lord, that no, it is not required that for the whole period, there is no such provision that it must be continued for the whole period. And it is a copy Tripura. Well, para 15, you'll also see. May I read, my lord? We do not find the objection as raised by the respondents to oppose the petitioner claim on transport subsidy are valid. I may read 14 also then. Okay, in the case of the northeastern region, for raw materials moving entirely by road or other transport, the transport cost will be limited to the amount which the industrial unit might have paid, and the raw materials moved from Siliguri by rail up to the railway station nearly the location of the industrial unit, and therefore by road. Similarly, in the case of the movement of the finished goods moving entirely by road or other mode of transport in the northeastern region, the transportation cost will be limited to the amount which the industrial unit might have paid had the finished product moved from the location of the industrial unit to the nearest railway station by road and thereby by rail by Siliguri. We do not find any objection as raised by the respondent to oppose the petitioner claim on transport subsidy are valid. To begin with, the objection that the petitioner's activity did not amount to manufacturing activity has not been raised by the respondent in the official correspondence. In any case, it does not require much effort to turn down such an objection. The admitted fact is that the petitioner is engaged in crushing big boulders into small chips of stone used in the construction activity. Thus, an entirely new article through the mechanical process which the petitioner subjected the raw materials to the comes to in the existence. Further, the objection that having started as a manufacturing unit, the petitioner later on was engaged in the activity as a job worker also would not make the petitioner ineligible for the transport subsidy. It is the principal agency for whom the petitioner may be carrying out the job work would bear the cost of transportation, and when such an activity claimed transport subsidy, the question of its eligibility may not be examined. However, the petitioner has claimed transport subsidy during the period in which it had undertaken the transportation of raw materials for a manufacturing activity. The eligibility period for claiming subsidy may be for 5 years. The scheme nowhere provides that only if an industry needs continue such manufacturing activity for a period of 5 years, that it can claim transport subsidy. Therefore, even if, as pointed out by the respondents, the petitioner at some later point of time after commencing his commercial production got engaged into the grant in the same activity as job worker, this would not amount to any breach of eligibility conditions of the scheme.
Yes.
So, my lord, the ground which has been given by the respondents to the effect, my lord, that was non-operational at the time when they visited, and they visited in the year after the judgment was there, that is nearly in 2017. And prior to that, my lord, the order was passed in 2018, my lord. And 2017, they said that it was not functioning. And I communicated to them, my lord, that because of the ban of the on coal, the unit is not functional. And the same will be functional only when the ban is lifted. So, my lord, there cannot be any reason whatsoever to say, my lord, that the unit must be functional for all the times to come. In any case, my lord, you'll also find that 2009, I started commercial production, and 7 years will expire in 2016. And they visited the unit in 2017.
Yes.
Now, a judgment of this honorable court, my lord, you'll also kindly see para 8. Para 8, my lord. The affidavit of position filed by the respondent number 22 in both the disposition clearly shows that the claim of the petitioner was duly verified, and recommendations were made for payment of the amount of transport subsidy in favor of the petitioner. Court has then also raised a specific query from the London Council appearing on behalf of the industry department as to whether it is the necessity of the transport subsidy scheme that the industry unit concerned has to be functioning as on the date on which the amount is to be released, or it is necessary to make the verification as to whether such raw materials or finished products were actually transported or not. The London Council appearing for the behalf of the industry department with all fairness submitted that though it is the requirement of the scheme that the transport subsidy is to be released without any delay, at the same time it is also required to be looked into as to whether the raw materials and finished products in respect to which transport subsidy has been claimed were actually transported within the framework of the said scheme. The London Council appearing on behalf of the industry department further submitted with contour that their entitlement of the petitioner has to be ascertained on the basis of the materials as to whether the petitioner actually transported the raw materials as well as the finished products or not. This court had also perused the transport subsidy scheme and also taken note of the fact that the petitioner unit was duly functioning at the time when the claims of transport subsidy were made, and this aspect of the matter would be clear from the certificate issued by the General Manager District Industrial Center so that the petitioner unit was physically verified on so and it was found functioning as on that. Even the affidavit of position of the respondent revealed that the petitioner unit had to be closed down sometimes in January 2018 due to financial crisis and the shortage of raw materials. Under such circumstances, it is the opinion of the court that the respondent authority, more particularly the state government, ought not to have rejected the claims of the petitioner on the ground that with effect from the January 2018, the unit was not functioning. According to this court, therefore, sets aside the decision of the state level committee taken in meeting so, whereby the petitioner's claim were rejected, as well as the decision taken in the meeting, whereby the petitioner's claims for transport subsidy rejected on the ground that the petitioner unit was found to be closed since January 2018. In the above backdrop, that this court finds it relevant to direct the state level committee to decide on the 16 claims of the petitioner as tabulated above in the basis of transport subsidy scheme, and further on the basis of whether the petitioner has transported raw materials as well as the finished products in question. This court further is of the opinion that in the circumstances and the basis of the materials available on a state level committee has no doubt shown so. Now the very fact, my lord.
What is your claim here? What benefit?
Sales tax exemption.
Sales tax.
My lord. Now the very fact, my lord, that the assessment has been levied, completed, and the tax has been levied on me, will show that in that period I was functioning. If I was not functional, then the assessment order should be passed. So the very fact that during the period under consideration, my lord, the assessment orders have been passed and tax has been levied on sale made by me from my industrial unit will clearly show that during that period the unit was functional. If their case is that the unit was not functional from the very beginning, let the assessment order go. Instead of 99%, I will get 100%. Total exemption. On the one hand, my lord, they say that tax has been levied, that eligible certificate was not issued. And on the other hand, they say that at the time of verification, the unit, my lord, has was not functional. This is neither in the scheme nor in the policy that the unit must function not only for 7 years but continuously. Assuming for the argument's sake that the rule 52A would not have been in challenge, I would have got the eligible certificate in 2010 itself and got the necessary benefits. So, there is no dispute that during the relevant period, the unit was functional, for which the assessment orders have been passed. And on the ground that in 2017, the unit was found to be non-functional, on that, the eligibility certificate cannot be denied. More particularly when the petitioner by communication informed the authorities that the unit is not operating because of the ban imposed on the coal by the NGT. And the same, they shall start operating again whenever the coal is available. Can the respondent say that although there is a ban imposed on the coal, but the unit which is based on the coal, raw material coal, must be functional? How it will functional? the requirement is that, my lord, the person must establish a industrial unit, new industrial unit within the state after the specified date. And if that is done, then the benefits which are specified in the policy shall be available for a period of 7 years, subject to the limit specified in the scheme. If this interpretation of the department will not be accepted, then, my lord, it will give a classification between an industrial unit who closes down after issuance of the eligibility certificate even during the period of eligibility, and an industrial unit who has not been issued the eligibility certificate and subsequently closes down is denied the benefit even for the period when it was functional and was eligible for the benefits. One cannot give benefit to one industrial unit. Well, assuming for the sake of argument, I'm making the argument, my lord. A person has come only for taking the benefits of the sales tax exemption. He established the industrial unit. Just a hypothetical case, my lord. And after establishment of the industrial unit, got the eligibility certificate, got the entire benefit of the sales tax exemption of the limit, availed the benefit, and closed down. Can, in such a case, the department can say that we will recover the amount. There is a provision, or either there is a provision, any provision in the policy scheme act that such a benefit which was given shall be recovered from that person because he has closed down the industrial unit. Another example I'm giving about capital investment subsidy. As you also hear, capital investment subsidy at the relevant time was available, I think 33% of the total investment made in the new industrial unit. A person establishes the industrial unit, avails the benefit of the capital investment subsidy. He has taken 33% of the subsidy. After 3 years, closes down. Whether there is any provision in the policy scheme that capital subsidy, whichever is given, will be recovered from person, that you must continue for 15 years. Third example, my lord. After 3 years, I become bankrupt. Insolvency process is there, is over. Can they say that no, you cannot become bankrupt? If you become bankrupt, we will not give you anything, whatever is then, that also will be recovery. Since there is no such condition in the policy scheme or anywhere that it must continue for a particular period, if the respondents can show a single line from anywhere that unless and until the industrial unit continues production for a particular period, they shall not be entitled to the benefit of the exemption. In that case, my lord, till the expiry of that period, they cannot issue the eligibility certificate to anybody because they must wait. That whether that period is over or not, how they can give the benefit? So this is my entire case, my lord. That the eligible certificate which has been rejected is absolutely illegal. And I am entitled for the benefit of the sales tax exemption, VAT exemption, for the period during which the unit was functional. And since for the relevant period, the orders of assessment have been passed,
Who has rejected?
my lord.
Who has rejected the certificate?
My lord, the state level committee said rejected and said the commissioner of industry and commerce to pass a speaking order and communicate. In the earlier case of this honorable court also, my lord, the state level committee.
State level?
Committee. And there cannot be a dispute that during the period my unit was operational, even for the sake of repetition, again, I'm repeating, my lord. Because if that would have been so, then there could not have been any sale from my industry unit and consequently no levy of tax. Once you have levied the tax for the relevant period, that itself indicates that during that period, my unit was operational. Only the exemption has been denied on the ground the eligible certificate was not there. So, my lord, in the cases, I'm giving a list, my lord. In the cases where the eligible certificate is in challenge, if I fail, then subsequent petitions will also be dismissed. And in case I succeed in the eligible certificate, then the subsequent assessment orders have to be set aside by giving a time limit to the authorities to issue the eligible certificate so that I can produce it before the department for taking the benefit. Yes, first half. Well, I am giving a list, my lord. The first list of 5 items is eligible certificate, and balance is the assessment order. Lordship kindly mark it.
First 5 items, what
eligibility certificate. So where the eligibility certificate has been rejected.
rejected?
Lordship, item 9.2. 9 to 13 is the eligibility certificate rejection cases, and the others are for assessment.
That I given 9 to 13.
9 to 13.
Yes.
So that's 9 to 13, but I given the WPC number, so
9 to 13 of today's date.
and rest are assessment order for different assessment. In fact, I have nothing further to say. This is my input. Submission for lordship, and I rely on the 2 decisions.
Reply.
Subject reply, if they can show me not a single line from anywhere, I will also be gather knowledge, and so far I have my knowledge goes after reading the policy and etc. I have not got a single line. This is my submission.
Yes, responded.
It's from sales tax department.
Basically, lordship, the first industry department has to
Industry
make.
department has to mean.
Yes, industry.
Sales tax department is also.
Confidential order. See, my senior is not present here.
Right. You give a date when
Thursday, 6 of
6. So 6 June it will be there, one more matter is there, so you'll also pick it.
Sorry?
One more matter that carbonated is there, so there is no difficulty about 6 June.
6.
He's saying about 6 June.
6 of part of the by Mr.
TK Bora.
Part Mr. Chaudhary for
Finding that
finance and Mr.
and Kalita for
and
industry.
Mr. and account- It is apply by the account- and it is apply by the account. It's not 6. And it should be part.
Obliged.
But these are short issues, but the matter is pending from 2018.
We'll try to complete
My lord.
the next week.
So that in the chamber, our chamber also some space may be there, my lord. The space are occupied only by these files.
We'll try to assure you that
I'm highly obliged.
right.
Sometimes, Lordship, we ourselves get confused. The parties are same, but the issues are different while taking out all those briefs.
Now, we never get confused about the files because that much we have to take care. At least from the commercial angle, my lord.
Okay. 6. Okay, where's the, you're there on behalf of Mr. B. Chaudhary? Yes. Oh, pardon. Fine, fine. Sure. But it's so much. Employed as Villa. That's under the Assam right. Petitioner and then husband. Applied for granted casualty for 5,095 85. The expiry of the leave is protected by the in the case of the petitioner that he suffered from medical ailment in TB and was therefore not in a position to receive his degree. So the authorities were duly informed and subsequently petitioner said husband upon recovering from his illness proceeded to receive his degree. However, the authority refused to allow it. Being agreed, we filed a writ petition number 355 seeking a direction from the court for permit him to withdraw it. The petitioner it has been however expired. The petition said writ petition closed and for infractors. Earlier writ petition which you filed,
It was closed with the direction that she'll be entitled to claim monetary relief.
closed with the direction that the petition has been expired and the present petitioner was substituted as a petitioner. However, this court that since the writ petition was filed for issuing a direction respondents to permit their husband of the petition joining the late husband of the petitioner having expired in the pendency of the writ. The writ petition was closed, giving liberty to the present petitioner for filing or approaching this court again for any financial benefit that may be entitled.
Page 55.
The petitioner thereafter approached this court by filing WPT number 5759. There are two writ petitions filed.
Two writ petition. One is a deserter, they have been declared in deserter, that was challenged, thereafter dismissed. The dismissed both are satisfied by the owner.
Came that the petitioner did happen to the result and
After expiry.
thereafter was also dismissed from service. So, being agreed, both these orders were received by filing the 5759 of the 10th and the 5957. Both these writ petitions came. The primary ground of the writ petition was that these orders of desertion and dismissal from service was issued after the demise of a late husband. So both these writ petitions came heard and dismissed of together by already equal court by say judgment and order allowed the writ petition. So the orders of the orders declaring the late husband, the petitioner as a deserter, and the order for dismissal from service were set aside and quashed. So, by the same order, the court and bench directed that the late husband of the petitioner be treated to be in service till his death in 1984, and the period from 4/5/2000 1984 shall be regularized by the court. It was further held present petitioner being widow of their instrument shall be entitled on which and all such benefits it needs in the this order is not agreed for the
That 100,
138
101 your lord.
writ appeal also came dismissed by judgment by order dated 15/7. The judgment court dismissed the appeal preferred by the respondent and upheld the finding of the if the medical due to the restriction was not being preferred. Contemplation. A contemplate number
We will find
376 of 2016, page 94.
676 of 2016. The contempt during the period during the contempt case, during the pendency of the contempt was submitted, and before the contempt court was submitted, that family pension, death gratuity, and cost as awarded by the court have been released. However, the area salary payable to the dead husband of the petition or release on the principle of over contempt court upon such submissions to the contempt. Observe that the direction to observe that whether the direction to regularize the service for the above period direction to pay salary period will require indication in view of the stand of inputs over taken by the respondent. Contemplation of the input and repetition by present by the rate of areas and in view of the specific and categorical direction by the judgment and order by judgment and order 312 5759 2008 1979 by the coordinate directing that the petitioner be entitled all constitutional benefits due to the late husband and that such categorical view and such categorical finding and such direction of the coordinate bench would and must necessarily include the areas at play. Another council that since the coordinate bench arrived at the point that the order of declaring the repetition and exertion as well as the order of prepared and the 98. Maybe. It was regular, directed. Decide. Of no work at by not yet. That these are the
Two judgments here. Okay. One is uh, 2012 3 STC.
Yeah.
178, page 1.
and the other.
And other is 2014 1 GLR. 730. Page 7.
The respondent on the other end strongly objects the submission of the that where the not and like was not from 10 5 of the date of death
19/8, 2004.
2004.
During the pendency of the repeating.
Mayor that area that there is like better not exactly that support like get manager Haryana your done thing Singh
Okay. Yes, doctor. On last occasion, I submitted.
then it post payment that in word Taylor court AIL Aadhaar card. You know, the Aadhaar card. This was our gentleman. We have nine- nine- eight of the appearance. Eight of areas that there has that by word that 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 cost. So the amount that is
Out of three, your lordship, two have been released.
Lordship is find that running page 1.
it is page 96, isn't it?
Lordship.
Areas of family pension, death gratuity, and cost. What? No further thing. What areas are the- and therefore the not address the issue, confronting the court, and said that the judgment dated 3/12/2000 passed in W 5759 and 9/2000. This the Colonel Singh judge after detailed discussion fact had the book of the restriction only direction para 23 20 0 1 20 the appellate court while we held that the appellate court is in complete agreement with the view taken by the judge, and that the appellate if it respond to the hearing must immediately release all service benefits earned by the appeal. We made the judge that I if yeah, there are and at period salary there for that appearance will not get take draft if the right draft if the it will not be or expect that had claim the sorry for the after ailment on 1/8/2000 the authorities having rejected the petitioner's claim for presumed presumption of the not be dead husband the petition W355,000 filed by the date of the and during the matter which is filed. The other recorded bench upon the grounds and reasons the the order dated with past the judgment and order dated with past had categorically arrived at the finding that the order declaring the declaring the dead husband of Sar as well as order for description of Sar are contrary to the provisions of as well as all internal effects of every set aside and washed. The Learned Secretary relying on the judgment of Krishnakant Parmar held that all such unauthorized actions from the University of the not amount to misconduct if it can be proved that the absence will was not given. And if it cannot be proved that the absence is there is a categorical finding by the court and bench that the late husband of the retired should not join his as was inflicted. And ultimately, the petitioner's late husband did not receive rejoin his courted bench, therefore returned the finding that the order of desertion as well as the dismissal passed by the respondent against the late husband of the petitioner pursuant to his expiry. Clearly untenable, therefore was interpreted set stop. From the tenor from the findings of the learned single judge, it is evident that the court had come to mind that the absence of the data was not meaningful, and therefore this aspect ought to have been consciously considered by the respondent authority. The learned the court had been having arrived at the finding that that the absence of the petitioner or the failure of the absence of the late husband of the petitioner or his failure to join the duty being not willful, then the only inference that can be drawn is that no responsibility, no fault can be set on the late husband of the petitioner to have purposefully and willfully stay purposefully and willfully neglected to stay away from performing. The period for which the late husband of the petitioner does not render his service, as is evident from the judgment of the court, is because of the order of desertion and dismissal. It is because of the ill health, because of the medical ailment suffered by the late husband, and thereafter, because of the order dated 31/8/2005 passed by the respondent declaring late husband deserted and as well as dismissing him from service. So, under such circumstances, I had a finding that the failure of the electric consume is was because of the reason and has because of the reason and finding arrived by the coordinate bench. So no fault can be attributed on the late husband for not rendering. Consequently, that the late husband of the late ought to have been granted the DSL. That having not been done, the present right. So, however, having said that, there is one aspect of the matter that cannot be ignored. With the statement of the restriction that her husband reported for joining in duty on 1/8/2001 and having not been permitted having not been permitted to join state the earlier restriction by independence. According to the law, the petitioner the right or grant various salary with effect from 1/8/2001, the date of the death. And so the prayer for, do you have any prayer for interest? No.
But the post may be imposed earlier, post was imposed.
All right. The writ petition according to the law, the area salary is directed. Of 3 months.
Taken up on Tuesday next month. Tuesday next month.
You're appearing for an adjournment.
So in fact, I inadvertently misplaced the file somewhere.